Good afternoon. Welcome back, ladies and gentlemen. Hope you all got recharged from the lunch and for this afternoon's sessions. Welcome back. We'll move on to the very exciting sessions focused on international commercial, digital, and financial law. We have the privilege of having three highly distinguished speakers joining us here on stage. Now let's welcome Professor Geraldine Go-Escolar, Deputy Secretary General of the HCCH. Welcome to join the panel. Let's welcome Professor Jingxia Shi, Professor at the School of Law, Renmin University of China, RUC, and Professor Emily Lee, Associate Professor at the Faculty of Law, University of Hong Kong. Thank you, ladies, for joining us. Very lovely. Okay, so firstly, Professor Go-Escolar will be speaking on the topic of normative work at the HCCH. The Central Bank Digital Currencies Project, HCCH, UniJoint Digital Assets and Tokens, DAT Joint Project, Digital Economy Project, and Insolvency Project. Professor Go-Escolar, please.
Thank you very much. 在香港现场以及在网上参会的各位同仁、同事们、专家们、朋友们，大家下午好，我是吴美山，海牙国立师法会议的副秘书长。Good afternoon, ladies and gentlemen, and a very warm welcome to Hong Kong. Thank you for joining us today. My name is Geraldine Go-Escolar. I address you today as the Deputy Secretary General of the HCCH and also as the head of the International Commercial, Digital and Financial Law Division. Welcome to those of you online as well joining us. We've heard we have several hundred people online, and thank you for your patience. We have been having some technical difficulties, which has been solved by the magic of the people at the back of the room, so thank you very much. Now, before I start, allow me to thank our organizers and hosts here and give our appreciation to the generous hospitality of the People's Republic of China, and in particular, the Department of Justice of Hong Kong Special Administrative Region, and as well to our host today, the University of Hong Kong. Today, I have the privilege of speaking to you about the normative work of the HCCH in international commercial, digital, and financial law. I will speak about all of these projects that Amelia has listed and then some more, and I promise to try and keep it within the time slot that I have. So I'm going to do the scariest thing, just try and move this thing. Let's try and see if that works. And there you go. That's the word cloud that we put together in my team to look at all the different ideas and concepts that we have when we're considering the private international law implications of international digital law, international commercial law, as well as international financial law. You see there, of course, in green, all of the big picture concepts, so digital economy, transactions, tokens, and so on. Then the dark blue concept, which is what we really want to achieve by way of principles, access to justice, party autonomy, sustainable development, and of course, the theme of this year's conference, which is access to justice and sustainable development. These are two really big themes that we also want to talk about and to bring to the forefront for our members at the HCCH. Now, if I may, why are we speaking about this? 130 years on, we are still looking towards the progressive unification of private international law, and that means for us facilitating cross-border interactions. This means for three really big categories of beneficiaries, individuals and families, business and commercial operators, as well as public institutions. So those are our big constituencies present in every member and every state and jurisdiction that we address. And what we'll talk about today is the digital economy. And the digital economy is quite particular. Now, all of our work and all of our instruments, we focus specifically on technology neutrality. So when we talk about commercial and digital, it's actually quite interesting because how do you remain technology agnostic and technology neutral while still addressing these developments? So that's really one of the things that we discuss every day at work. So we look at the technological advances, the growth and the trends and uptake, and challenging traditional legal concepts in the work that we do every day at the Permanent Bureau in my division. Now, why do we do this? As my Secretary General has mentioned, 2030 is really around the corner. And to achieve Agenda 2030 and the 16 UN Sustainable Development Goals, one of the ones that we always talk about is SDG 16, strong legal institutions, the rule of law, and how important that is really to the building of peace, to the building of inclusion, as well as diversity, not just in human rights, which is really fundamental and basic, but also in financial inclusivity. Why is that? Because SDG 1 is basically freedom from poverty. And if we do not break the poverty cycle, if we do not have financial inclusivity, we will never see true equality on this planet. And so that's what we believe, and that's what my team works towards. We try to see if through private international law, we can engage the world community to really bring financial inclusivity, access to capital, access to finance in the work that we do. Now, what we found is this. For every 1 unit of currency put in by our government into digital technologies, the yield is 20. So for every Hong Kong dollar that the government puts into technology that relates to fintech, to digitization, to digital transformation, the yield down the line in 5 years is $20. That's the highest return on investment and the highest amount of basically profit that you can get off a public investment. What also we've seen is, in terms of non-digital investment, is a 6.7 times. 6.7, so 670% difference, meaning that when the money goes into digital transformation, what we're seeing in return is a huge return on profit. Now, today what we'll talk about actually is the PB's normative work. So the work that we're mandated by our members to do, which focuses on developing binding international instruments and monitoring and researching priority subjects that our members tell us are interesting, relevant, feasible, and timely for the subject of future work. Now, as I mentioned, absolute investments in top tech trends remained very strong last year in 2022 at more than $1 trillion, US dollars combined, and that indicates quite a lot of faith in the value potential of these trends. Now, $1 trillion is 5% of China's GDP last year, and all of that is locked up in digital transformation. Web3 last year attracted $62 billion in equity investment, and just as equity investment. And despite all the tumultuous forecasts of Web3, analysts have forecast that $4 to $5 trillion worth of tokenized digital securities could be issued by 2030. So, this is the current normative work at the HCCH. We'll just run quite quickly through these 5 projects. And on our website, you will find the documents for these projects. And then, if I may, I'll give you a sneak peek into something new, maybe a little cheeky, but something new that we're going to look into and propose to our members as well next year. And these 5 are the Digital Economy Project, the Central Bank Digital Currencies Project, the HCCH UNIDOA Digital Assets and Tokens Joint Project, Insolvency, and Intellectual Property, and this brand new one that we'll just talk about just a little later. Because it's after lunch, and I want to keep people interested till the end, so we'll talk about that in the end. All right, so let's move on a little. Digital economy. The Digital Economy Project really is the epicenter of the Commercial, Digital, and Financial Law Division's work. Now, under this project, the PB continues to examine, monitor, and assess developments and trends in the digital economy, as well as financial technology or fintech. And it looks at new innovations, and as well as the adjacent technologies and the applications that may have implications for private international law. So in particular, this monitoring project focuses on the rise of platforms, services, and products that are delivered or designed on distributed ledger technology. Why is that special? Because as all the private international law experts in this room knows, a lot of the connecting factors have a locus. So a connecting factor on the basis of geography. And the moment we have something digital, something online, that's it. All the borders are lifted, and it's not quite clear exactly how we're going to make that connection. That geographical connection is something that gives us that connecting factor to let us know which law is applicable, which court has jurisdiction. How do we recognize these sort of decisions? And when we have something that's maybe a little different, we're looking to see, can we still apply what we have? And if not, how do we iterate it? Now, this is quite important. We do not make new work for the sake of it. We are very aware at the Permanent Bureau that we subsist on public financing, and so the work that we do first must add value. Second, should be timely, should be feasible, should be desirable. So when we look at these two factors, we always consider the instruments and the frameworks we already have. This achieves two things. One, we don't do double work, and so resource-wise, we are pretty efficient. And second, we don't fragment the law. So we look at the other organizations, UNCITRAL, for example, the United Nations Commission on International Trade Law, UNIDROIT, both of them are sister organizations. We look at what they're doing, and we make sure that our work is in line and builds on, but never then fragments from the work that they do. So if you're interested in further information on this, let me direct you to the proceedings of our inaugural conference last year. Now, it's Commercial Digital Financial Law, and so we call it the Codify Conference. And the Codify Conference last year in September of 2022 was streamed online. You will find everything online on the HCCH YouTube channel. 93 speakers, I believe, and more than 100 hours of content on the private international implications of the digital economy. Now, what was important about the Codify conference last year was that it was instrumental to the launch of two major exploratory projects that we're working on this year. And the first one is what we call the Central Bank Digital Currencies Project. Now, this is quite interesting and timely because just yesterday, the Hong Kong Monetary Authority, together with the Bank of Israel and the Bank of International Settlements, released their report on retail CBDCs and how that would work across borders in the sandbox to see what kind of issues there would be. So we're now at the exploratory phase, which means that we're looking at how this project will be scoped. We have a group of experts, and we're looking at these questions. Applicable law, as you know, in a cross-border circulation, what is the law that would be applicable? Jurisdiction, what kind of court or which court would have jurisdiction in relation in particular to intermediaries? Recognition and enforcement, so how will judgments in CBDC systems be recognized and enforced? A bunch of different questions, and we then had an iterated scope paper that was put out. Now, why is this important? As far as we're aware, the World Bank says that approximately $120 billion of tokenized cash is now in circulation in the form of fully reserved stablecoins, for example, the USD coin. Now, that is 30% of Hong Kong's GDP. And that's already right now in circulation. Now, what's also interesting is this, globally, so we look at the whole population of the Earth, between 1.4 and 1.7 billion people are today still unbanked. That is the population of the whole of China. That is an untapped group of people who are completely unbanked, and we hope with digitization and digital transformation can then be included in the global digital economy. So what does this mean? In developing economies, the share of adults making or receiving digital payments grew from about 35% in 2014 to approximately 57% in 2021. We saw the growth in particular in the COVID pandemic. Now, in high-income economies, the share of adults making or receiving digital payments is almost universal, so 95%. However, what we found was that in the more emerging economies, it is actually the pandemic, as well as receiving payments from public institutions or from employers, that has caused these people to become banked. So we're seeing an increase in digital payments for these people to receive their income. Now, what's also important is this. Digital banking allows trade and commerce and products to flow across borders because payments can go across borders then. And what we found is that this in particular has a great impact on small cottage industries, and in particular on industries which are home-based and run by women. And so we hope that this will be a project which can have some sort of impact as well on human rights, on women's rights, and to help the unbanked get involved in the digital economy. Maybe something interesting in China, 82% of adults made a digital merchant payment in 2021. And in that year, in 2021, there was actually an increase of 11% who did so for the first time since the start of the pandemic. And that's 11%, 100 million adults just in China in 2021 were new to this whole system. So as I said, we have a group of experts that are sitting with us to scope the project and to ask the questions So what are the questions that need to be asked? As you all well know, projects are as good as the questions that we're asking, essentially. So we ask the experts, which questions should we be looking at? Are there actual private international law questions? Of course, the first answer that always comes back is, if it's regulatory, is it outside the scope of the HCCH? Is a digital currency, because it's issued by a central bank, is there a cross-border element? What happens if it's issued by two jurisdictions together? Is there that cross-border element? How will that circulate? And these are the questions that were put to the experts. I put them into two columns. The first one that you see on the left is really kind of a taxonomy exploratory thing in terms of discussing what we're talking about when we're saying digital currencies. And that really is exploring the existing landscape. We found that something like 91% of the global GDP comes from economies that either have sandboxed, piloted, or have in circulation digital currencies or CBDCs. So 91% of the GDP now belongs to these jurisdictions that have some sort of digital currency in the works or already circulating. So we're looking at the existing landscape. We want to see, are there regulations? Are there already rules or customs in place in terms of applicable law, in terms of jurisdiction? Have there been disputes that have arisen? And if so, how are these then addressed? Is there a cross-border element? We found at a prima facie level that yes, there seems to be some cross-border element. And so then we move on to the next question, which is a matter of taxonomy and definitions. And there the questions that our experts put forward are, aside from CBDCs, which are central bank digital currencies, there are various other forms of this sort of payment systems. So for example, we do have jurisdictions that don't have a central bank issued digital currency, but have adopted, for example, cryptocurrency as legal tender. Then the question arises, is legal tender something that needs to be discussed? What is legal tender? Is there a cross-border element there? Is there a private international law element there? Do the CBDC technical frameworks allow for cross-border trade? And what happens with intermediaries? If there's a dispute, what happens there? Is there an applicable law issue, or is it just simply the law of the issuer? How does that work? How about jurisdictions that recognize CBDCs or crypto? How about those that ban them? What happens if you do a cross-border transaction that kind of goes through all of these jurisdictions? And these are the questions that the experts put to us as part of the exploratory scoping exercise that they think are important for us to consider. Then, of course, we move to that side of the right column, which is a bunch of different things to consider: characterization and the applicable law. So question, what is a digital currency? Is it a property? Can it be used in a secure transaction? Can you use it to secure a loan? What is this thing? Is it contract law that applies? Is it a payment system? What is this thing? And then, of course, the circulation and payment systems as a whole. Is this payments law? Is it something else? And all the public policy considerations. As I said, some jurisdictions banning it, some really actively promoting it. Is crypto different than stable coins, and how do all these things work? And then what happens with intermediaries? These are the questions that the experts considered in a kickoff meeting that we had, and they're now considering their answers to these questions. We hope to have their input by this Friday, so in 2 days from now, and then we'll consider and see what happens. And I invite you all then to join us for the next iteration of Codify, and that's edition 2023, focusing on CBDCs. It will be streamed online on the 5th of October this year. What we'll do is we'll have some pre-recorded videos. We're going to release it that day on the 5th of October, and then have a couple of panels that will summarize and analyze the input that we received from our experts. Where does this all go? We will report to our Council on General Affairs and Policy, to our members essentially, on the outcomes of this study, including proposals for next steps at the next meeting in March of 2024. So that's the idea, our first project, and now it's our flagship project of this division. Now, quite quickly, I'll take you then to the HCCH UNIDOR Digital Assets and Tokens Joint Project. It's a very long name, so we call it the DAT project. It's a very street name, so it's cool enough for digital assets. That's the DAT project, and the DAT project is quite historic for us, because even though UNIDOR is a sister organization and we work very closely with them, this is the very first institutional project between the HCCH and UNIDOR. What does it do? Last year, basically, UNIDROIT's working group on digital assets and private law concluded their work. And they came up with a set of principles on digital assets and private law. That set of principles was approved by the UNIDROIT Governing Council on the 12th of May last year. And in that set of principles is Principle 5 on the applicable law, so the law that would apply in proprietary issues relating to digital assets. Now, we sat as an observer for the last 3 years with UNIDROIT, and together with the UNIDROIT Secretariat, came up with a proposal to both our memberships, saying maybe we ought to look a little further into this question of what law applies to digital assets and tokens, to linked assets, to things like soul-bound tokens. What happens in those kinds of new applications and assets and tokens? And so this basically is a project, also the exploratory phase, to scope what exactly this means. So Principle 5 of the UNIDROIT principles addresses only proprietary aspects of issues relating to digital assets. And it's basically defined to be assets for which there's control. So electronic records for which there's control of that record. And so we have then a question of, are there other things, other kinds of assets? And so we had tokens. And the exploratory study then asks 8 questions. The first one, of course, is whether there is an applicable law in the absence of an explicit or valid choice of law. How do you protect weaker parties? Should we even consider this? What connecting factors would impact on the law applicable to cross-border holdings and transfers? What is the law applicable to linked assets? What definitions, terms, and other considerations will be relevant when we're considering the scope of this study between the 2 institutions? How will we express party autonomy? Do we need to work on the matter of characterization? So what are these assets and tokens? And should more connecting factors be explored? So as we start to move towards different applications of these sort of digital assets and tokens, we start to have different kinds of considerations. Some of these tokens incentivize people to put forward their identity and their location. And if they do that, it's quite easy to then connect them. And so then you know what the applicable law might plausibly be. But some of these assets then do the opposite, and the incentive is actually not to identify yourself. And then we start to have an issue with the connecting factors. So these are the questions that we're asking. And then we move on to the bit more substantive questions, both from the private international law and the private law point of view. How about contractual aspects in a transaction of these sort of digital assets and tokens? Should we consider that? Would the choice of law rule apply in relation to transfers and acquisitions? How can consumers be protected? In fact, today with artificial intelligence, we always assume that in these big monolith companies that the consumers are the ones which are in the weaker position. But it could well be that a consumer who really knows how to use artificial intelligence might be an augmented user, and so might actually know more than the person they're transacting with behind the internet screen. And then, of course, other kinds of assets, linked assets, digital twins, digital triplets, other kinds of novel assets. What do we do with these sort of things? These questions are also now in an iterated scope document. There was a kickoff meeting on the 12th of June this year, and we've just received all the experts' input. We will go to another meeting at UNIDROIT 2 weeks from now. So we hosted the first one, UNIDROIT hosts the second one, and basically in the first week of October, we will have the input from that meeting. And again, that input goes into a report, which we will take to our membership in March for a decision as to how, if at all, but how to move forward. And then UNIDROIT will take the same to their governing council in May, and we move forward from there. So just interestingly, something to work between UNIDROIT and us, private law, private international law, the implications on each of the both. And I was born a public international lawyer, so from a geek point of view, from an international organizations law, this is fantastic. How do you get 2 different international organizations to work together? That's historic, and that's what we're doing today. Then quite quickly, let's move to insolvency. And insolvency is quite particular. There, we work with our other sister very often, and that's with UNCITRAL. So UNCITRAL Working Group 5 focuses on insolvency, in particular on applicable law and civil asset tracing and recovery. And we sit as an observer on the PIL matters specific to those, but as you know, applicable law is PIL, and civil asset tracing also is procedure-wise related to private international law. So we sit on Working Group 5 as an observer. But at the same time, we do have a mandate to monitor developments and study within the digital context as well. So the question of the qualification of digital assets and choosing the law applicable for insolvency proceedings with a cross-border element. whether insolvency involving DLT or crypto assets should be addressed with ordinary rules, so the ones that we already have, or do we need specialized guidance, if at all? We look at the third-party effects of digital asset service providers, also how to protect consumers, and the mechanisms of tracing and recovery for digital assets. Can you have injunctive relief? If so, what's a technique? And how do you value what's called unique assets? So it has a bad name today, but non-fungible tokens. So things which are different. It's unique and that's just one asset. How would you value that asset in insolvency proceedings? What law would apply? And of course, this thing is something that has carried on for insolvency for quite some time, the recognition and enforcement across borders of insolvency resolutions, basically. So what happens there? This is a monitoring project, but our work mostly focuses on the cooperation that we have with UNCITRAL. Now, we can't talk about digital economy without intellectual property, so just quite quickly, let me just touch on that. We do work quite closely with the International Bureau of WIPO, the World Intellectual Property Organization, and at least for private international law matters, we're looking at three big categories: big data, the characterization, what law is applicable, and so on for big data, including the jurisdiction and what court will be competent over such data, which is across borders. We look at artificial intelligence, different national approaches to IP protection. Can AI invent? Can you have a patent on something that originated from AI? How does that work? What are the cross-border differences on the ownership of AI-generated inventions? And that's what we're looking at the moment. And the third one on non-fungible tokens, we're actually looking at immersive technologies. Immersive technologies has a cooler name, which now also has a bit of a reputation, metaverses. So when you have metaverses and immersive technologies, and there are non-fungible tokens within that metaverse, which then doesn't actually belong to a particular country, where is the jurisdiction there? What law applies? How do we characterize the NFTs? Those are the questions that our experts say are important. But again, the IP project is a monitoring project for the moment. We haven't escalated it to an exploratory study. What's interesting about the presentation slot that I got was that it talks about normative work. But let me just touch quite quickly on the two conventions you will hear a bit on later on in this session, which are the Trusts Convention and the Securities Convention. But I want to touch on those from the specific point of view of decentralized autonomous organizations, or DAOs. And there, in particular, we're looking to see whether regulated DAOs can be recognized in other states. And in fact, what is the applicability of the 85 Trusts Convention? We're looking at it from basically the specific point of view of whether DAOs behave like trusts. So as an organization, does it behave like a charitable organization? Is it a trust? And if so, does the Trust Convention apply? We're also looking at maverick DAOs to see how would they be considered to exist, what is their legal status in various jurisdictions, and what law would apply. And then the question of whether DAOs need to comply with securities laws, and whether further work needs to be done in relation to that for intermediated securities, or maybe a protocol on disintermediated securities that will be attached to the Securities Convention. Again, this is monitoring and looking to see if it makes sense. And if not, then of course we won't invest much more resources into it. But as a study, I think it's, at least it fascinates me. So I quite quickly didn't want to go to the last thing, which I think is quite important. And this is to do with carbon markets. Now, this might sound a bit off because we're talking about commercial, digital, and financial law, so what's it got to do with the environment? And quite a lot, actually. Now, this is brand new, so I think you might be the first audience to hear about this outside of the scope of this. On July 21st of this year, so about 6 weeks ago, the United Nations Commission on International Trade Law met in commission form to decide the work program of UNCITRAL going forward. And one of the things that they discussed was climate change, resilience, mitigation, and adaptation, right? And climate change is very important. As we know, we just had a typhoon, floods everywhere. Things are not looking great for the environment. And one of the wonderful things about trade is that trade and environment are inextricably linked. And so UNCITRAL is putting forward a proposal that they need to also look at the trade-related aspects of climate change resilience. What does that mean? In cooperation with the UN Framework Convention on Climate Change and the Kyoto Protocol, as well as the Paris Agreement, there are all these carbon credits, which I'm sure you've heard of. And in the carbon credits, just to put it quite simply, there are two portions of it we need to look at: voluntary carbon credits and the regulated markets. And the question that was put to us is, What are these credits? Are they property? Can they be used to secure a loan? Are they a stream of revenue? What law would apply? Why does this matter? For certain members of the HCCH, Brazil, Bolivia, they're carbon positive, meaning they have credits to trade. If we can find out what these things are, what these credits are, they potentially could provide a revenue source for the government. So you can trade these things, but you need to know what they are before you trade them, and you sell something you don't really know how to deal with. So this is a proposal that we have at the moment. We do not have a mandate at the HCCH to work on this, and in fact, we might be one of the last rule of law organizations that is not with a specific mandate for environmental work. So what we're doing is this. Under the umbrella of cooperation and coordination, we will work with UNCITRAL, who now has a mandate to scope voluntary carbon credits. Separately, UNIDROIT last year received a mandate for a working group on the private law implications of voluntary carbon credits, and we sit there as an observer as well. UNCITRAL and UNIDROIT will work together because they have a mandate now, and we will contribute as an observer until next March, where we hope our council will agree with us that the private international implications might be something to look at. If we get that mandate, it will become a tripartite coordination and cooperation plan in conjunction with the UNFCCC, the Paris Agreement Secretariat. Why is this important? The fact is, if there is a trade and finance related motivator, it's a catalyst for things to happen. We're not saying that trade and finance is more important than environment. We're saying that trade and finance and the legal certainty around it can help with climate change resilience. And if it's a tool, why don't we leverage it? So on that basis, we're going to put forward a proposal to our council to ask them if this is something that they would like us to look at, to see the private international implications of regulated and voluntary carbon markets. So that's a proposal that will go forward this year, at the end of the year, towards council for next year's meeting, and we'll then find out what the mandate is or will not be. So these are the topics which are being undertaken by the HCCH with an eye to the future, of course. We talked about this quite a lot this week, 130 years looking back, 130 years looking forward. And we want to focus really on sustainable development of economies, both developed and emerging, and we want to look to ensure that private international law frameworks remain relevant and allow our society to leverage digital transformation as well as other technological applications. I'd be happy to take any questions after my co-panelists have spoken. I thank you very much for your attention.
Thank you so much, Professor Escola. Absolutely fascinating. It's such an attractive topic that our speakers are back to the audience seat. Thank you so much. And there's definitely a lot for us to process and chew on. So more topics on this regional perspectives. Now let's invite Professor Jingxia Xu to the podium. Welcome.
Thank you so much, our very beautiful and seasoned moderator. Ladies and gentlemen, good afternoon. First, please allow me to offer my wholehearted congratulations to HCCH for its 130th anniversary. I think I'm already very old over half a century, but HCCH 130th anniversary is definitely worthy of our respect. Second, I want to offer my sincere gratitude to the conference organizer, including very long-term dear friend, Professor Zhao Yun, for having me here. It's always my great pleasure visiting Hong Kong, particularly Hong Kong U, because my good friend Emily is here. Okay, anyway, realizing I have very limited time, I think it's about like 10 minutes. Sorry, I couldn't benefit from, the last 2 days presentation because I just flew in from Tokyo this morning. I hope my presentation will not have too much overlap with what you have already heard. My former fellow panelist, Professor Ascola, I hope my pronunciation is correct, already made a very comprehensive and informative presentation about normative work of HCC has been doing. And also thank you for the very latest information about digital, commercial, and the financial work had being done by HCCH. So in my presentation, I would like to focus on three aspects. First, I think you have already listened a lot from Professor Ascola about the cooperation among three sister law organization, which is UNIDROIT, HCCH, UNIDROIT, and UNCITRAL. I talk about this because of my personal experience as one of the governing council of UNIDROIT for the past 10 years. Second, I would like to briefly touch about you talk about insolvency project, particularly listen to what you just mentioned. But I want to fill a little bit of gap, tracing back to the current UNCITRAL project with relate to applicable law in insolvency proceeding, because this, I think, has been largely ignored. Thirdly, I would like to talk about the impact of HCCH's norm work on Asia Pacific, particularly for Asian countries. But be mindful that my view is only like I'm an academic, so this is only my personal observation and some of my thoughts. So about the cooperation among HCCH, UNIDROIT, and UNCITRAL within the community of international law. These three organizations are often referred as three sisters of private international law, due to their very preeminent position as a legislative organization involved in harmonization of private law. Sister law organization, I think this term not only emphasizes the strong linkages between those organizations, but also perfectly captures that close relationship, much like the relationship between siblings in a full love family. The HCCH, as its age at 130 now, serve as the eldest sister of the trial, to be followed by UNIDROIT, which almost 100 years, and UNCITRAL, which much younger. As we can see from the historical and institutional aspects of the three sisters, it reflects a very ever-increasing cooperation among those organizations instead of rival. I think this is very important because Professor Ascola mentioned, they don't, with this cooperation, they don't fragment law. This is very, very important in today's world. In addition to what Professor Ascola just mentioned, I want to also offer very recent examples for the close cooperation among those organizations. The first one is the so-called tripartite legal guide to uniform legal instruments in the area of international commercial contracts with a focus on sales, which was adopted by those three organizations in 2020. And also in 2019, as you mentioned, those three sisters have been considering collective work on emerging legal issues relating to digital technologies such as AI, blockchain technology, and etc. I think you mentioned enough, and I will see my words here. Again, in addition to, not fragmenting law, also in this very connected, interconnected world, I think the cooperation of CCH, which is younger sister, has become very, very important. I have been personally witnessed, how close cooperation they have done as a governing council member of UNIDRA for the past year. And by the end of this year, my second term will be expiring. But I had the luck and witnessing, at every governing council meeting in May in Rome, and the Secretary General both from UNCITRAL and UNIDRA, they sit in the room and talking about all these project being done and project to be done. So what also the implementation for, I noticed there are a lot of scholars here as well. I think, when we talk about the project done by one of them, we have to look at, other two sister organizations. The relationship will help you have a more comprehensive viewpoint. So my second part is very briefly on the cooperation on insolvency matters, because insolvency law has been one of my extremely important area of expertise. I have been doing this for the past over 3 decades, since 1993. I want to mention, in addition to what Professor Ascola mentioned, actually in its preparation of a draft legislative guide on insolvency back to, the beginning of this century, not only cooperation with UNIDRA, but also, I believe, with World Bank as well. At that time, the UNCITRAL sought cooperation with HCCH with a view to assisting it in preparing commentaries and recommended legislative principles in relation to law applicable to insolvency proceeding. Following that, a meeting of the secretaries of those two organizations has taken place in Vienna in December 2003 with regard to this project. As you can, if you consult the website of HCCH, you still see, pursuant to this request, the Permanent Bureau of HCCH devised a questionnaire and to facilitate the work, which they received 14 responses have been received. Why I particularly mention this, because I have been watching closely about the ongoing project on the applicable law insolvency proceeding being conducted by UNCITRAL right now. So of course, this will be very very technical. I just want to very, very briefly mention, because this, given the relevance of conflict of law issues in insolvency proceeding, for example, determination of applicable law in case with international or cross-border dimensions, we can see principles contained, principle actually from 30 to 34 on applicable law in UNCITRAL Legislative Guide 2004. So the point I'm making here is that actually the carrying on project right now at UNCITRAL actually was very, very much originated from early this century from HCCH. I don't want to touch upon various technical issue here because of the time limitation. Lastly, I would like to mention the impact of HCCH's normative work on Asia. I said it's a regional perspective, focusing on commercial law because my area is commercial law. So, but we remember this is, I cannot stand for this region. This is just my personal perspective. How remarkable we have been seeing, the HCCH has been very important global player to unify private international law between different countries and divergent legal system. From its very beginning in 1893 until now, HCCH has been increasingly global, involving more and more countries, including the countries coming from so-called global south. Many of them are from Asia. If you consult the website of HCCH, you will see since 2000, they have developed 44 new members. I noted 16 of 44 are in Asia. So from my personal observation, I think fundamentally this not only illustrates the rising importance of Asia, both economically and politically, but also exhibits the HCCH, the successful strategy in attracting or in expanding its membership beyond Europe and North America. But on the other hand, from when we look at Asia, we can see the economic, social, and technological developments in Asia are also very remarkable in recent decades, because I do not only private law, but public law as well. So we can see there are a lot of regional economic agreements have been signed, including CPTPP, RCEP, and etc. Those movements, I think, very effectively enhance international trade and the business transaction among the Asia-Pacific countries. Yesterday, I heard from Tokyo conference, which is on insolvency law. For the economic outlook, many people have been very pessimistic. But when we look at Asia, still, the mainstream perspective is that despite the economic downturn in recent years, partly affected by COVID, but Asia's regional integration still continues to deepen. I think this already has generated, but will continue to produce an impact on the legal framework of private international law on commercial matters. I think the previous speaker, even I was not here for the the last 2 days. I think a lot of speakers have been talking about 2005 and 2019 conventions. I will save my words here in the interest of time. Turning to China, we can see mainland China has been a contracting party to 4 instruments. The number is not that big, but soon it will become 5, because we see 1961 Post-Tao Convention will come into force in China in November. China has already signed 1 convention, that's 2005 Choice of Court Agreement. When you look at the convention in force for Hong Kong, as well as for Macau, SAR, it seems that mainland China, we have more work to research, to more looking at the instruments HCCH has been doing. Another point I want to make is that along the economic developments and increasing business transaction in Asia, setting up effective dispute resolution mechanism is also very, very crucial. Our Chief Judge Gao from Supreme Court also here, I believe maybe she already touched upon the topic, but I want to mention, this year, not only marks the 10th anniversaries of BRI, Belt and Road Initiative, as well as the 10th anniversary of the establishment of China's free trade zone or free trade port in not Hainan, but Hainan is not 10 years old, but this is, the overall strategy to opening up more for China. So I think against this background, recognition and enforcement of judgments constitutes a key component of, the mechanism will, help, will implement both the BRI project and FTZ strategy. Realizing that it's not easy, as well as it's also costly for China and participating country in BRI to promote only by bilateral or even multilateral dispute resolution mechanism is very. I'm not saying it's not possible, but it's not easy as well as it's costly. So I think harmonizing private law, particularly on commercial matters, it's an efficient way for both for China and for other countries to have more close relationship in terms of international trade and investment. Lastly, I would like to offer several concluding remarks. I want to see international legal harmonization is not a zero-sum game. So cooperation among those three sisters are very important. By supporting each other, these organizations not only enhance the reputation of the entire family, but also further the ultimate goal of the world with harmonization of the commercial law, private law. Turning to Asia, the rapid economic developments, despite the economic downturn, as well as gradually advancement of regional integration in Asia, may require more of common legal settings in the future. So the development towards enhanced legal cooperation and coordination is of great importance. I believe it could be expected in Asia along with the ever-increasing project and more wide presence of HCCH in this age. Also with an increasing presence in Asia, the HCCH may be invited to address some, I'm not sure whether this is academic suggestion, address some particular concerns or of these Asian countries in selecting or promoting future projects and as well as during the process of conducting treaty instrument negotiation. So lastly, while for Asian countries, including China, while joining certain HCC instruments may pose challenges, but from my personal view, I think it's worth contemplating in the long run with a view to living up to so-called international standards and improving the domestic legal system as well. I thank you so much for your time and for your listening. I'm open for the questions if you have. Thank you.
Thank you. Thank you very much, Professor Xu. Thank you very much for sharing this very rich content of your discussion. Thank you. And feel free to join the audience because we're going to have more topics on the regional perspectives. Nextly, let's invite Professor Emily Lee to the podium. Welcome.
Actually, I'll just use this. Yeah, it'll be much easier. Good afternoon, everyone. My name is Emily Lee. I'm from the Faculty of Law of the University of Hong Kong. I would like to begin my presentation by expressing my gratitude to the HCCH for inviting me to participate in this very distinguished panel. The topic of my presentation is the cooperation mechanism and legal harmonization in insolvency proceedings across mainland China and Hong Kong, with insights from EU insolvency legislations. Regarding the title, the cooperation mechanism is the colloquial term used to describe a combination of the record of meeting, the practical guide, and the 2021 SPC, Supreme People's Court in China opinion. This overarching term, cooperation mechanism, encompasses the three agreements between the authorities in Hong Kong and the mainland China on matters involving recognition of each jurisdiction's insolvency or bankruptcy procedures. The complete titles for the record of meeting, the practical guide, and the 2021 SPC opinion are provided below their respective abbreviated titles. Before delving into the intricacies of the cooperation mechanism, it is crucial to establish some historical background. Judicial recognition and assistance between Hong Kong and mainland China can be viewed in two distinct stages, before and after the handover. Prior to the handover, while Hong Kong remained a British colony, judicial recognition and assistance was governed by international treaties, such as the New York Convention and the Hague Convention. The United Kingdom extended the New York Convention to Hong Kong in 1975, therefore making it applicable by the courts in Hong Kong for recognition of arbitral awards. The Hague Convention improved the organization of mutual judicial assistance in cases of civil or commercial matters to enable a judicial or extrajudicial document to be served abroad. The United Kingdom also extended the Hague Convention to Hong Kong in 1970. After the handover of Hong Kong to the Chinese sovereignty on the 1st of July, 1997, the legal basis for recognition and assistance is built on two pillars. The political pillar, known as the one country, two systems, and the legal pillar embodied in the Hong Kong Basic Law, Article 95 to be specific. To further elaborate, after the handover, Hong Kong and China relied instead on arrangements to facilitate judicial cooperation in accordance with Article 95 of the Basic Law in Hong Kong, including first, that is the 2006 arrangements. The full title is Arrangement on Reciprocal Recognition and Enforcement of Judgments in Civil and Commercial Matters by the Courts of the Mainland and of the Hong Kong Special Administrative Region, pursuant to the choice of court agreements between parties concerned. And the second one is the so-called 2019 arrangement, the full title being Arrangement on Reciprocal Recognition and Enforcement of Judgments in Civil and Commercial Matters by the Courts of the Mainland and of the Hong Kong Special Administrative Region. The signing of the 2006 arrangement further led to the enactment of the Mainland Judgments Reciprocal Enforcement Ordinance, which accords the implementation of the 2006 arrangement with statutory backing. For an update, the 2006 arrangement underwent significant amendments in 2019 and was retitled, becoming known as the 2019 arrangement. Compared to the 2006 arrangement, in paragraph 5, Article 3 of the 2019 arrangement, it specifically excludes bankruptcy insolvency cases. The 2019 arrangement has not yet come into force. The Legislative Council, that is the legislative body in Hong Kong, passed the mainland judgments in civil and commercial matters reciprocal enforcement ordinance on the 26th of October last year in 2022 to implement the 2019 arrangements, although it has not yet in force. It follows that currently, other than the cooperation mechanism, there exists no feasible option for liquidators in Hong Kong or administrators in China to seek recognition and assistance which will enable them to perform their functions. At the heart of the cooperation mechanism, as established by the record of meeting, selected mainland courts in designated pilot areas can initiate judicial cooperation with Hong Kong courts. In the same fashion, the designated courts in China are able to receive requests from liquidators or provisional liquidators sanctioned by the Hong Kong courts. The 2021 SPC opinion has designated courts in Shanghai, Shenzhen, and Xiamen as pilot areas. It provides that any Hong Kong administrator, for example, liquidator, applying for assistance and recognition from the pilot areas courts require a letter of request and a copy of the judgments authorizing such to be issued by the High Court of the Hong Kong SAR. I note that there are certain similarities as well as nuanced differences between EU's insolvency regulations and China-Hong Kong arrangements preceding the cooperation mechanism in relation to cross-border insolvency proceedings. There are two notable similarities. First, a comparable approach can be found between Europe's Brussels Convention of 1968 and two arrangements between Hong Kong and China prior to the cooperation mechanism, namely the 2006 arrangement and the 2019 arrangement, in carving out bankruptcy insolvency proceedings. The exclusion was deemed necessary in the initial stage of drafting the Brussels Convention, when it became clear that a separate insolvency convention to deal with the insolvency of both individuals and companies seems to be the only method of achieving harmony in this area of law. Similar to the evolutionary approach adopted in the EU for the enactment of EU insolvency regulations, the cooperation mechanism represents an ongoing process of negotiation aimed at enhancing legal cooperation between China and Hong Kong. The subtle differences pertain to the unique characteristics of the cooperation mechanisms are, first, unlike the Brussels Convention, which provides a formal uniform framework for mutual recognition and enforcement of judgments in civil and commercial matters, the 2019 arrangement does not yet constitute a formal mechanism for the same purpose. Second, with the branding of a pilot major, the 2021 SPC opinion could very well be seen as a temporary measure to guide the intermediary courts in Shenzhen, Shanghai, and Xiamen, i.e. the pilot courts. Having said that, it It is also not uncommon for China to enact legislation on a trial basis in order to test the effectiveness of new initiatives, although the legislation nevertheless still has the force of law. It might well be the case that this practice is employed for the 2021 SPC opinion, especially if both China and Hong Kong are not yet ready to reform their cross-border insolvency laws. Finally, it remains to be seen how impactful the 2021 SPC opinion is. One way to gauge its impact is by judging the frequency of letters of requests sent by the Hong Kong courts being honored by the three appellate courts in China. This concludes my presentation today. I welcome any comments or questions that you may have. Thank you very much.
Thank you very much, Professor Li. Please join us on stage. Please have a seat. Professor Xu, please come up to the stage and have a seat. Thank you very much to join this Q&A session. Now, ladies and gentlemen, we have three gorgeous professors on stage. If you have any questions, don't hesitate. Just raise up your hand. Okay, this lady.
Thank you, the three professors on the stage. I have two questions about the HCCH carbon credits proposal. First, I would appreciate the work of the HCCH to look into the equitable law regarding the emission trading system, especially when there are maybe issues regarding the linkage between different ETS markets. Actually, my questions are, because ETS is just one of the market-based instruments, there are other market-based instruments like, such as intensity-based caps and carbon taxations. So how can HCCH can make laws that or measures that can transit the voluntary compliance of the carbon markets to compulsory ones? And my second question is about legal safeguards of the carbon crooks, because there is a documentary film about the Denmark ETS system in 2013. There are hackers who stole the Danish government's lot of the carbon credits. That means it's a total collapse of the carbon credits. It means that it is more easier to pollute. I mean, it is not, because of the price of the carbon credits is fall. So it seems that it is more, more easy to pollute than to save the climate, save the planet. So it didn't seem to mitigate any climate change. So will the HCCX project also look into cybersecurity, or are there any cross disciplines studies in this area? Thank you.
Thank you for your question. So, Professor Escola.
Thank you very much. Can you hear me? Yes, perfect. Thank you for your questions, and those are very pertinent questions. And I'm afraid that my answer may not completely satisfy you, which is basically that the mandate, a specific institutional mandate of the HCCH, is on civil and commercial matters. We do not look at criminal matters. We certainly don't look into government regulations on this sort of topic. So that's one important thing. So any kind of private international law study that we may or may not have a mandate for next year will focus on civil and commercial matters in relation to these carbon markets. We will not touch the other parts of it because we have no mandate to do so. Then my next point will be perhaps related to this point I've just made, which is that, as you very correctly pointed out, there's a bunch of different frameworks already in place. Stems all from the UNFCCC with the Framework Convention, with the Kyoto Protocol, the Paris Agreements, and so on. And it was made very clear on the floor of the Commission at UNCITRAL in July that there are discussions ongoing there. So the Paris Agreement, for example, is still on the table. We're still discussing it. What's very important is that whatever's happening there is not compromised by any kind of work that's done outside of it. And what's also important is that the UNFCCC, as the UN members made quite clear on the floor of the Commission, is based on common but differentiated responsibility. So there is a whole bunch of policy and maybe even political considerations there, which again is not within the mandate of the HCCH. So I do very much appreciate, and I am aware of the topics that you have brought up. These are really for a mandate for other organizations who are very actively discussing this to consider. As I said, we have no mandate at the moment. We are going to bring it to our members because we've been asked to contribute our resources and expertise on the matter of private international law implications of the carbon markets, and specifically only to that. We have no mandate, so we will, of course, contribute to the best of our abilities. As Professor Shi has said, this is a sister organization. We really want to cooperate with them and contribute where we can. And so that's where we're going to focus, but we're going to stay within our mandate. I'm afraid I might disappoint you in relation to that question, but that is the truth then of it. Thank you so much.
Thank you, Professor Escola. So do we have more questions?
Yes. First of all, I would just start with a very big congratulations to Professor Geraldine Goes-Escolar and everyone at the HCCH. I would say that what you have presented in front of us today is more than spectacular. And just to put into perspective, Codify was exactly 1 year ago, and actually the scope of the mandate that has been provided to the HCCH addresses so many interesting and adequate questions that the private international law community is facing. Now, what I just wanted to ask in terms of all these normative projects, normative work, is essentially you briefly touched about how these potential future instruments of the HCCH will influence the rest of the already adopted instruments like the Securities Convention, for example. But in order to put it in perspective, in comparison to the rest of the instruments, because we're speaking in the last couple of days about coherence between these instruments, how these future potential conventions coordinate each other with the already established instruments like the choice of court convention, for example, because party autonomy is one of the already suggested solutions for many of the issues that digital assets, for example, provide in front of the private international law community. And I know that all these projects are in very early stages, so maybe there is room for future discussion on these matters, but I was just wondering whether this is already discussed and there are already insights on this.
Please.
Thank you for that question, and you're absolutely right. Exactly this time last year, we were panicking on this ridiculous conference that carried on for 5 whole days. I don't think I slept 2 hours in that week. So you're absolutely right. This was exactly a year ago, the Codify conference. I think perhaps we need to take a couple steps back from the questions that you put forward, which is the first thing is no fragmentation. That's unbelievably important. And what we're saying is that we always look at the instruments that we have already existing, and then we see if there is a gap to fill. Transnational litigation, for example, and the transnational litigation conventions apply across board to civil and commercial matters unless it's excluded from the scope. It means that, for example, you could use, for example, the service and evidence conventions for family law matters. That's possible. And I don't think there's a question there. However, there are certain things which have scope issues as well. So, for example, 2015 Principles on Choice of Law is an international commercial contract. So you need, by default, an international commercial contract to apply those principles, whereas not a commercial contract, we have issues again. So when we're looking at the Codify section of work, let's say, so digital and so on, I think it's quite important to understand that digital falls within 2 baskets. One, where the transformation as a result of digitization produces certain digital vulnerabilities, which are separate than the human vulnerabilities we already address in the other conventions. Those are the ones we're looking at. When it comes to other vulnerabilities, there are conventions that would apply, and there's no reason then to kind of reinvent the wheel, let's put it that way. Then the second point is, we also, as you mentioned actually quite correctly, we're very early stage. And the method of work at the HCCH is not to say we're going towards an instrument. We don't know if we're going towards an instrument. And we will only make an instrument if it makes sense to do so. Otherwise, it's a terrible waste of resources, and I don't think we want to do that. So where it doesn't make sense, that won't happen. Where it does make sense, there obviously is an identified feasibility and a need for it. That means there's a lacuna there, and that we will try to address. So I think that's the second point. The last point, which I'll make, and then I think my co-panelists probably have something else to add to that, is simply the point that when we look at digitization in and of itself, digital and technology does not change the application of any of the HCCH conventions. We're completely technology neutral. So we're not looking at the specific digital technology. We're just saying that when we digitize things, the applications may then raise certain questions we never thought of. Connecting factors may no longer apply. In those cases, what do we do? And then we might then have work that carries on, for example, a protocol maybe, or a guide to good practice on how you use the Securities Convention in that case. But we also have history, where we had 1954 Civil Procedure Convention, now superseded by the 65 Service and the 70 Evidence Convention. So that's also possible. It does not replace the 54 Convention, but it then provides other channels for more contracting parties to come on board. I will stop there, and I'm sure Professor Shi has something else to add to that. Thank you.
Actually, I don't think I have something to add to what you just mentioned. That's a very, very comprehensive answer. May I take this opportunity also asking one question to Professor Ascola? Because my question is closely related to the first question raised by that lady. It's a very good question. As a governing council member, at UNIDRA, actually, you mentioned the mandate, which is particularly important. Every international organization has its mandate. But in terms of the interaction between private law and the international law, actually these years at UNIDRA, there has been some discussion, because how can you clearly delimit, you have the boundary between private law and the international law. As you can see now at the UNCITRAL Working Group 3 has been doing SDS, which certainly has public law aspects, as well as I think that, ALEC, Agriculture Land Investment Contract at UNIDRA, also, interact with public law issue. I'm wondering whether this has been, I know, you may, criminal law matters, certainly out of your mandate, but how about the situation with respect to like carbon trade? You briefly mentioned that both like regulatory aspects and contractual or transactional aspects. So I'm wondering, this also, the question, particularly the interaction between private law and the international law, has been also facing by HCCH. Thank you.
Thank you for that question. May I invite you to join us perhaps on the work? Do you have something to add to that, Alice?
Professor, she said that she didn't have anything to add, but I do. I want to respond to that gentleman's question in regard to choice of law. I think it's a procedural matter. It definitely falls into the realm of the private international law because the goal is to ameliorate the differences in procedural matters between different countries. But taking the choice of law as an example, it's an issue that is more complicated than it seems, because taking the issue of COMI, for example, COMI stands for the Center of Main Interest, which is the connecting factor that is used to determine which court has jurisdiction. The very concept of COMI is open to different interpretations by different courts. And that's why, to respond to your question, I think it's actually a very different and very difficult issue perceived by different jurisdictions, regulators, as well as the judiciaries. So this is a point that I think that the complexity of choice of law should be heightened. And other than this point, yes, I don't think I want to add more weight on any of the issues such as ETF, because I like to borrow the analogy that you use. That is, HCCH does not have the mandate, and then I will say that ECF, green financing, and this kind of issues, ESG, is outside the scope of my expertise.
Wow, a lot sparks on the stage. Would you take the Professor Shi's question as the last question of this session, please?
I will do my best. It's a very good point. I think this is an issue actually that's not specific to the Three Sisters, but we're seeing in a lot of international organizations because more and more issues are quite cross-sectoral, quite interdisciplinary. And so, for example, at UNCITRAL, UNCITRAL is a UN body. And there were a lot of questions about how they would cooperate with the UN FCCC, which is right next door, actually. So if within the UN, two specialized agencies have issues as to who's doing what, in different organizations. So I think, just to answer your question, I think there are two components to this. One, which is the respect for the actual mandate of the organization. And there, I will put myself on a limb and say that the HCCH is in a special position where we deal with only our definition of private international law, which really is applicable law, jurisdiction, recognition, enforcement, and international cooperation mechanisms. And these four are all procedural matters. Whereas UNIDROIT deals with substantive private law, quite a lot of it, and UNCITRAL deals with substantive trade law. And there they might actually run a little more in parallel, closer to each other, to the wind. And our field is quite discreet, I would say. So I think that's one way that we're doing it. And of course, they're speaking among themselves, but we're not privy to that bilateral conversation. The other thing, of course, is this cooperation. So every year, without fail, the leadership of all three organizations meet in a tripartite where we sit behind closed doors and we really talk this thing through. How do we do this? We also observe each other's work. So back in 2018, you'll know this better, 2018, when it was 18 or 19, when UNIDROIT had their first mandate for digital assets. Was improved, yeah, it was approved in 18, that's right, because they have a triennial, so also the work programs and the schedules are different. So when they got the mandate for that, UNIDROIT Secretariat very kindly invited us to see, were we doing any work? And we had no capacity at a point of time, so we wrote back saying, look, we have no capacity, we'll sit as observers, and that's what we did for 3 years, to provide input to the UNIDROIT work without us actually having to have a mandate. And then after that, we realized that, there's a bunch of applicable law matters, and so then the joint project. UNCITRAL has done that with UNIDROIT for warehouse receipts, I believe, as well. And so now we do this for digital assets. Maybe we'll do it we're actually doing it now for voluntary carbon credits, one small part of it, where it will be a tripartite plus UNFCCC and so on. So that's what we're going to try and do. Also mindful that UNIDROIT has 60-odd members, 63 members. The HCCH has 91, so there is an overlap, but not completely. And of course, UNCITRAL has the United Nations membership. So the constituents are also different, and we serve the needs and the interests of our members. So that's quite important. I'll stop there. Thank you very much.
Thank you. Very inspiring. Excellent. Let's give a big hand to our outstanding ladies on the stage. Thank you. Thank you for giving us a very good panel. All right. Thank you, ladies. And thank you for your engagement for this Q&A session. Now, the next session is on the highly respected 2015 Choice of Law Principles. We will have 3 speakers for this session. Let's first welcome Professor Guan Jiantu, Professor of the Faculty of Law at the University of Macau. Welcome to the stage. And Professor Nobumichi Taramura, Assistant Professor at the Institute of Asian Studies, University of Brunei Darussalam, and Professor Priscilla Pratita Panasthika, Assistant Professor at the Faculty of Law, University of Indonesia. I love this diversity of names and laws, of course. All right, let's invite Professor Tu to give us an introductory presentation. Professor Tu, please.
Okay, thank you very much. First of all, let me say thank you to the Hague Conference on Private Financial Law for inviting me to attend this really great academic event, and also for inviting me to do this presentation. My responsibility for today is to introduce the Hague principles on choice of law in international commercial contracts to you, and also to tell you how nice they are. Basically, my presentation is going to be divided into 6 parts: why bother, a brief history, the purpose and scope, the nature of the Hague principles and who can use them, the contents of the Hague principles, the current situation outlook. Of course, I will put emphasis on the contents of the Hague principles. Why bother? We are living in an increasingly interconnected world where people are doing ever-growing cross-border transactions in the form of contract. Generally speaking, although we have been talking about the 3 sisters for so long time just now, right? There is no uniform contract law at the global stage, although we have the limited United Nations Convention on International Sale of Goods, which harmonized partially the international contract law on sale of goods. And although we have the UNIDROIT principles on international commercial contract, that has actually only provided a model law only for the general part of international commercial contract. Obviously, when 2 parties come together from different jurisdictions, and when they sign a contract, they need to know which contract law is going to govern their contract. That is a very important question for practice and theory. Indeed, for this purpose, in 2006, June, the Special Commission of the General Affairs and Policy of the Hague Conference decided to invite the Permanent Bureau to prepare a feasibility study on the development of an instrument concerning choice of law in international contracts. Obviously, this is not an easy job. After this, a series of events had taken place. And also, under the leadership of the Hague Conference and many stakeholders' participation, thanks to their hard working, eventually, in March 2015, upon completion of the necessary procedures, the principles on choice of law in international commercial contracts were formally approved on 19th March 2015. The purpose and scope. The goal of the Hague principles is A, to promote party autonomy for choice of law in international commercial contracts. But the Hague Conference did not intend to construct a complete system of choice of law rules for international commercial contracts because it is quite difficult to do the whole system. But the Hague Conference keeps the door to the lighter for the future. And the Hague Conference also intended to encourage the spread of party autonomy so that for choice of law for international commercial contracts, foreseeability and legal certainty could be obtained for practice. The Hague Conference also hoped to facilitate a certain degree of harmonization of laws on a national, regional, and international level. The Hague Conference is trying to promote party autonomy for international commercial contracts only, and not for all types of contracts, which might be too ambitious for the current stage. And the Hague Conference, on the one hand, tried to promote party autonomy, but on the other hand, has to put limitations on party autonomy. The nature of the Hague principles and who can use them. The Hague principles actually are a non-binding set of principles, not a formally binding convention. As said yesterday, the Secretary General said this is the only soft instrument made by the Hague principles, by the Hague Conference. And even the Hague principles are not supposedly a model law, but they were recommended for being incorporated into domestic law. They were recommended for guiding reforms for domestic laws. And also, they were intended to pave the way for a possible future binding instrument. the envisaged users include lawmakers, courts, and arbitral tribunals, and of course, parties and their legal advisors. The Hague Principles may be used by courts and arbitral tribunal to interpret, supplement, and develop rules of private national law. With very limited exceptions, almost all articles can be used by both courts and arbitral tribunals in the same way. Contents of the Hague Principles. Generally, the preamble and 12 articles comprising the instrument may be considered to be an international code of current best practice with respect to the recognition of party autonomy in choice of law in international commercial contracts, with certain innovative provisions as appropriate. While some provisions reflect international consensus, others reflect the view of the Hague Conference as to best practice and also sometimes for novel solutions. The scope of applicability of the Hague Principles. The Hague Principles will be applied to choice of law agreements in contractual matters. Although everybody knows what a contract is, however, what exactly a contract is, not that clear. But the Hague Principles do not provide a definition of the term of contract. The Hague Principles will apply to international commercial contracts. Then what is international? According to the Hague Principles, a contract is international unless each party has its establishment in the same state and the relationship of the state and all other relevant elements, regardless of the chosen law, are connected with only that state. The Hague Principles will only apply to international commercial contract. Then when can one say that contract is a commercial one? According to the Hague Principles, where each party is acting in the exercise of its trade or profession, then the contract between that parties are commercial. Of course, there are contracts that are commercial, that are not commercial in the eyes of the Hague Principles. Among possible other non-commercial contracts, consumer and employment contracts are specified by the Hague Principles as typical examples to be excluded from the scope of the Hague Principles. There are also other issues or subject matters that are excluded from the scope of the Hague Principles, either because there is no wide consensus on whether they are contractual or not, or whether they should be subject to party autonomy at all. For example, the capacity of natural persons, arbitration agreements and agreements on choice of court, companies or other collective bodies and trusts, insolvency, the proprietary effects of contracts, the issue of whether an agent is able to bind a principle to a third party. As said just now, the Hague Principles are used to promote party autonomy. Then, the most fundamental principle is a contract is governed by law chosen by the parties, as said in Article 2, Paragraph 1. However, to what extent party autonomy is allowed? According to the Hague Principles, the parties are allowed to choose different laws for different parts of the same contract, which means depassage is allowed. The parties are also allowed to make or modify their choice of law at any time if no adverse effect on the formal validity of the contract and third parties' rights. And there is no any need of connection between the chosen law and the dispute, according to the Hague Principles. The parties can also choose the law of any state, plus rules of law that are generally accepted as a neutral and balanced set of rules, unless the law of the forum provides otherwise. The parties can also make the choice of law in different ways. For example, in express choice, it must be made expressly, say clearly which law is chosen in a clause of the main contract. A tacit choice, it must appear clearly from the provisions of the contract or the circumstances of the case. In contrast with the practice in many common law jurisdictions, an agreement between the parties to confer jurisdiction on a court to determine disputes under the contract is not in itself equivalent to a choice of law. The same is true to an arbitral tribunal. Formal validity of the choice. The Hague Principles adopt the doctrine of informality. A choice of law is not subject to any requirement as to form. However, there could be reservation from the parties' contractual power. A choice of law must be subject to a form otherwise agreed by the parties. Agreement on choice of law. Generally, the agreement on choice of law shall be determined by the putative law, the purportedly applicable law. Here is very technical. Actually, it means if the parties have chosen which country's law as the governing law for the whole contract, then that governing law will determine the validity of the agreement on choice of law itself. Where the parties have used standard terms designating two different laws, and under both of these laws, the same standard terms prevail, the law designated in the prevailing terms applies. Otherwise, no choice of law is taken as having been made. If under the circumstances, the putative law as specified is not a reasonable one on determining the intention of a party, the law where the party has its establishment can come into play. The applicable scope of the chosen law. Generally speaking, if the applicable law has been chosen by the parties, that law shall apply to many aspects of the contract. Subject to de passage, as said earlier, the law chosen by the parties shall govern all aspects of the contract between the parties, including, but not limited to, interpretation of the contract, rights and obligations arising from the contract, performance and the consequences of non-performance, including the assessment of damages, the various ways of extinguishing obligations of the contract, and also prescription and limitation periods for the contractual liabilities, validity and the consequences of invalidity of the contract, burden of proof and legal presumptions, pre-contractual obligations. However, paragraph 1E here does not preclude the application of any other governing law supporting the formal validity of the contract that could be referred to by the choice of law rules of the forum. Other issues. Severability between the agreement on choice of law and the main contract. It means even if, according to the governing law, the main contract may not be valid, but the choice of a court agreement itself could still be valid. And renvoi is generally excluded by the Hague Principles. Where there is a relationship of contractual assignment, while the mutual rights and obligations of the creditor and the assignee shall be governed by the law chosen by the parties to the assignment contract, the assignment against the debtor shall still be governed by the law chosen by the parties to the original contract. The concept of establishment actually is important to the Hague Principles. However, no definition is given for this important concept. But if there are more than one establishment, the relevant one is that which has the closest relationship to the contract at the time of its conclusion. Apart from Article 1.3, as we said just now, when the Hague Principles allow the party autonomy, they also put limitations on party autonomy. Article 11 put limitations on party autonomy, but they are exceptional in nature. The limitations could be overriding mandatory rules of the forum overriding mandatory rules of a third country, public policy of the forum, public policy of a third country whose law should have been applicable in the absence of choice. Public policy or overriding mandatory rules of a law other than the chosen law that can be applied or taken into account by an arbitrary tribunal. The current situation and outlook of the Hague Principles. In early 2015, the Hague Principles served as a model to the legislator of Paraguay in promulgating a law on the law applicable to international contracts. In July 2015, they received endorsement from the UNCITRAL. In 2020, Uruguayan general law of private national law incorporated the Hague Principles. In the 2022 survey, it finds that 88% of the participating arbitration centers consider their institutional rules to be consistent with the Hague Principles. For sure, there would be more to come. Lastly, let me say, although the Hague Principles is a soft instrument, I hope this soft instrument could be harder than many hard laws. Thank you very much.
Thank you. Thank you very much, Professor Tu. Please have a seat. We appreciate your expertise. Now let's move on to hear some regional perspectives. May we first invite Professor Nobumichi Terumura to the podium. Welcome.
Okay, I'm Dr. Geraldine Go Escolar, distinguished speakers, distinguished guests, and ladies and gentlemen. It is a great pleasure for me to join this event as a panel speaker. I'm Dr. Nobumichi Terumura, assistant professor in business law at the University of Brunei Darussalam. I'm also an affiliate at the Center for Asian and Pacific Law at the University of Sydney. About my background, I'm an expert in international business law with a particular interest in international arbitration in the Asia-Pacific region. Thank you very much for having me on this panel today. I came from Brunei on the Borneo Island to join this event. However, I would like to comment on the choice of law principles from the perspective of Cambodia. This is because I'm now working on a research monograph on Cambodian private international law, which is to be published by Hart in Oxford as a volume in the Studies in Private International Law Asia book series. This book series is edited by Justice Anselmo Reyes of the Singapore International Commercial Court, who is a past representative of the Hague Conference Asia Pacific Regional Office. As far as I know, the courts and the tribunals in Cambodia have not used the 2015 principles yet. So I will comment on 2 points. One, what may encourage Cambodia to use the choice of law principles? And two, what may discourage Cambodia from adopting the principles? So now, let me speak about the first point. The 2015 principles have a strong potential to become a useful reference tool for Cambodia to develop its rules on conflict of laws for international commercial contracts. This is because Cambodian private international law, especially conflict of laws rules, is still at an early stage of development. So since 1993, Cambodia has strived to develop a modern legal system, often with support from international donors, such as the United Nations, the Asian Development Bank, France, and of course China, and Japan. However, choice of law has not gained much attention from Cambodian jurists. So Cambodia still needs legislation addressing conflict of laws comprehensively. And as you know, the envisaged users of the principles include lawmakers. And the commentary of the principles suggests, for lawmakers, the principles constitute a model that can be used to create new or supplement and further develop existing rules on choice of law. Because of their non-binding nature, lawmakers at the national level can implement the principles in full or in part. Cambodian lawmakers may find these features of the principles helpful and probably convenient because they likely need a model upon which to develop their legislation on conflict of laws. And Cambodian judges may find the principles helpful too. In Cambodian judicial practice, the principle of party autonomy is recognized for choice of laws in international commercial contracts. However, how the courts have recognized the doctrine of party autonomy might attract attentions or criticisms from foreign scholars. Some Khmer judges have reportedly adopted party autonomy by relying on Article 3 of the Civil Code of Cambodia, which provides party autonomy for private persons at the substantive law level. This solution is curious and is unlikely to be supported widely by private international law scholars outside Cambodia because it has recognized party autonomy for conflict of laws solely based on the substantive law of Cambodia. So Khmer judges and other legal experts may have to find reliable guidance on choice of law. And the envisaged users of the principles include the courts. The principles, as you know, the principles provide guidance for courts as to how to approach questions concerning the validity and effects of a choice of law agreement and resolve choice of law disputes. Such guidance will help Khmer jurists. In Cambodia, the judicial training of judges does not provide trainee judges with opportunities to learn much about private international law. So Cambodian judges are generally unfamiliar with private international law and need a handy guide to that area of law. However, of course, there are some challenges to using the 2015 principles in Cambodia. First, in my view, the principles have yet to gain global acceptance or recognition. According to the website of the Hague Conference, only Paraguay and Uruguay have laws that somewhat implement the principles. This kind of lack of international support is unlikely to assist the promotion of the principles in Cambodia. Cambodian lawmakers and jurists are keen. They are keen to import international best practices. However, they are cautious about adopting legal instruments prepared by the Hague Conference. In fact, besides the 1993 Adoption Convention, Cambodia has not ratified any conventions or other legal instruments prepared by the Hague Conference. So Cambodian lawmakers and jurists might need more time to regard the 2015 principles as a guide to the best practices of choice of law. And second, Cambodian courts may need help to apply some rules in the principles. For instance, Article 11 of the principles provides in paragraph 1 that these principles shall not prevent a court from applying overriding mandatory provisions of the law of the forum. The principles do not define the term overriding mandatory provisions like other international instruments. So the court of the forum is required to determine whether a particular provision of the forum law has mandatory and overriding effects. However, it is not settled yet which provisions are mandatory and overriding under Cambodian law. So it is not easy for Khmer judges to identify overriding mandatory provisions of Cambodian law. In addition, Article 11 of the principles provides in paragraph 2 that the law of the forum determines when a court may or must apply or take into account overriding mandatory provisions of another law. This term, another law, is explained by the commentary as the law of a state other than that of the forum or of the law chosen by the parties. Such broad language being used without any potential limitation may be concerning for Cambodia. This is because it may require the courts in Cambodia to have a careful examination of laws that are potentially relevant to the case at hand. Also, most Cambodian judges are not experts in comparative law. So to conclude, there are pros and cons for introducing the choice of law principles into countries like Cambodia, which do not have a well-developed private international law codification. Nevertheless, I hope and I'm confident that the principles will help modernize choice of law rules in Cambodia and beyond. That's all from me. Thank you very much for listening.
Thank you. Thank you very much, Professor Taramura. Please have a seat. Now, ladies and gentlemen, continuing with the topic of regional perspectives, we now invite Professor Panastika to take the podium. Please. So maybe we just take a few moments to fix this problem first. Well, our arranged tea break will be in 10 minutes, so why don't we have the tea break now and come back later?
Good idea, tea break now.
Okay, thank you. So sorry. All right, ladies and gentlemen, we fixed the problem, and I believe you all grabbed some snacks, stretched your legs, and got some energy booster. I'm so happy you're back. Now, let's invite Professor Panasdika again to the podium. Welcome.
I hope everybody's feeling refreshed after the break, after the unexpected incident. So, Deputy Secretary General Goe Scholar, distinguished ladies and gentlemen, good afternoon. Continuing the discussion on the 2015 principles, my presentation today will address 2 points. First, the Indonesian stance towards choice of law in international commercial contracts, and second, the influence of the 2015 principles on the choice of law provisions in the Indonesian Private International Law Bill. As already mentioned by Professor Kusumadara in her presentation this morning, Indonesia has not had codified PIL rules to date. The prevailing primary provisions of Indonesian PIL are stipulated in Algemene Bepalingen van Wetgeving voor Indonesia. This regulation is inherited from the Dutch East Indies colonial period that dates back to the late 19th century. So, as you can see on the slide, none of this provision addresses matters on choice of law. In Indonesia, choice of law in international contracts was introduced through the works of legal scholars initiated in the 1960s. And in absence of comprehensive PIL code, only since 1999 was choice of law acknowledged in a statutory provisions. To date, only these 3 laws address choice of law in Indonesia. However, they hardly provide clear guidelines on how and to what extent choice of law may be exercised by the parties or may be given effect by a court or by an arbitral tribunal. In light of the limited statutory framework, the extent to which the Indonesian courts give effect to choice of law is also, well, unpredictable. The courts have 2 dominant approaches to handling choice of law in international commercial contract disputes. First, the courts put forward choice of foreign law as the reason to refuse jurisdiction over the disputes. And second, the courts applied Indonesian law to their disputes irrespective of the choice of foreign law by the parties. So in short, the courts conflate the notions of choice of law and choice of court, and the courts are reluctant to enforce a choice of foreign law by the parties. This reluctance ascribes to a number of intertwined factors involving the disputing parties, including their lawyers, and of course the judges. But owing to time constraints for today's presentation, I will discuss only one factor, and that factor is the shortcoming of regulatory framework on choice of law. So, due to this shortcoming, the Indonesian judicial practice, in this sense, the lawyers representing the disputing parties, and also the judges, have recourse to the freedom of contract principle stipulated in Article 1338 Indonesian Civil Code. So you can imagine the freedom of contract, the freedom of the parties to create a contract and to determine the terms and conditions therein in the context of domestic substantive law is used to justify and to set the restriction to private international law. The reference to this freedom of contract principle has frustrated the application of choice of law. And I will zoom in this problem from the judge's perspective. So, the judges who oppose choice of law have relied on this article to support their view that the parties have to execute what they have agreed to in the contract. Since the parties have chosen a foreign law, their contractual dispute is not of the competence of the Indonesian court because the court does not abide by foreign law. Refusing jurisdiction over contractual disputes to which a choice of foreign laws should be applied is thus claimed as the way to honor the parties' freedom of contract. Meanwhile, the judges who express more positive outlook toward choice of law would invoke this article to reverse a choice of foreign law if it did not conform to the prevailing laws, good morals, and public policy in the domestic context. Both interpretation perceive choice of law merely as an ordinary contractual terms in the context of domestic substantive law. It shows that Article 1338 Indonesian Civil Code on the freedom of contract principle is actually unable to function as a justification, let alone guideline, because it does not touch upon the idea of or the notions of choice of law in the context of private international law. And this is where the 2015 principles play an important role. So since 2019, Indonesia has been intensively working on its private international law bill, taking the benefit of the instrument's non-binding nature. The 2015 principles were observed and taken into account during the drafting process of the choice of law provisions in the bill. And today I will highlight some provisions in the bill that show striking correspondence but also striking divergence with the 2015 principles. First, the bill only allows an expressly written choice of law. This stipulation is somewhat stricter than the 2015 principles, Article 4, the 2015 principles, which allows an express, a tacit, and an oral choice of law agreement. Unlike the principles, the bill rules out any tacit, a tacit and an oral choice of law agreement in any form. The bill provides that a choice of law agreement shall remain binding upon the parties even if the contract it governs is declared null and void or invalidated. This stipulation was inspired by Article 7, the 2015 principles. According to the bill, choice of law shall not override mandatory rules, morality, or public order applicable in the forum. The elucidation of Article 50 of the bill further specifies that the term the forum is to be understood as Indonesia, or the place where the contract is concluded, or the place where the contract is performed. In comparison, as to the limitation of choice of law, the principles establish that the forum may apply its own mandatory provision or take into account those of another law. And as to public policy, the principles establish that the forum, other than its own public policy, the forum may also take into account the public policy of the law that would be applicable in the absence of choice of law. Moving on to Article 51 of the bill, which permits partial or multiple choice of law. And this stipulation took note of Article 2, Paragraph 2, the 2015 principles. This is going to be interesting. So the bill addresses that a choice of an Indonesian court can only be inferred as a choice of Indonesian law on the grounds of two circumstances. First, there is a situation of absence of choice, which then demands the court to ascertain the law of the place that has the most real and substantial connection with the contract. Second, the court failed to ascertain that law. I think we are all aware that the 2015 principles do not address a situation of absence of choice. Nevertheless, it appears that Article 53 of Indonesian bill, well, somewhat diverges from Article 4, the 2015 principles, which underlines that a choice of court is not in itself equivalent to a choice of law. Last but not least, the bill prescribes that Indonesian courts may take into account the validity of a choice of a law commonly or widely used in the field of contract at an international or regional level. In other words, the bill acknowledges a choice of non-state law by the parties. And Article 3 of the principles was the inspiration of this provision in the Indonesian bill. Apart from the provision that I've just explained, some other provision, well, in my opinion, could use some more or some further clarifications and improvements. And I believe, in this regard, I believe that the 2015 principle will continue to serve as guidelines and references for Indonesia and also for the advancement of the bill. The approval, regardless some concerns and obstacles, the approval of the bill is highly expected in the near future. When approved, it will serve, well, it is hopeful, at least I am hopeful, that it would serve the Indonesian judicial practice to have a more positive approach toward choice of foreign law in international commercial contracts. When it is approved, it will also reinforce the role of the 2015 principles in modernizing choice of law rules at a national level. Finally, I would like to conclude this presentation by congratulating the HCCH for its advancing work, for all its hard work advancing PIL rules across the globe all these 130 years. I also would like to thank the HCCH Asia Pacific Week organizers for the kind invitation and for organizing this illuminating event. And to all of you, thank you for listening.
Thank you. Thank you very much, Professor Panastika. Please have a seat. Back to the stage. Thank you very much. Now, ladies and gentlemen, it's again a very interactive session. Oh, I'm so tall here. All right, do you have any questions for any of the guests here on stage? Please feel free to raise your hand. Any questions? Oh, okay, that lady, please.
Testing.
Many thanks to the speakers for the great presentations. I have a question to Professor Tu. Yeah, given that the Hague Principles in Choice of Law is a soft law, that it is not legally binding, so how extensive is the use of the Hague Principles by the courts or by the commercial community? Yes.
Professor Tu, please.
Let me clarify first. Even it is not a soft law according to the report of the Hague Conference on Preferential Law. To answer your question shortly, you can see the last slide of my presentation. Actually, I'm telling you in practice how much it has been actually accepted. I could understand, as just now in the break, Professor Xiao talked with me about the actual implementation of the Hague Principles in a specific country. You see, in a specific country, when we are talking about how the Hague Principles can be used, we have to make sure they place the right position of the Hague Principles could be. For example, whether the Hague Principles can be taken as international custom for choice of law rules. Say like Chinese law, if it can be taken as a international custom choice of law rules, sometimes maybe it could also be directly applied by the courts as well. So it depends on how to interpret this. And also for arbitral tribunals, you see many times, you see arbitral tribunal, they are not confined to the strict choice of law rules of the seat of the arbitral tribunal. And they may have more flexibility. Sometimes it depends on the choice of law rules in the arbitral rules they have chosen, or sometimes even there are no any choice of law rules in the arbitral rules chosen by the parties. The arbitral tribunal may choose the Hague principles to apply to determine the question. Thank you. I hope I can understand your question. I have answered your question. Thank you.
Thank you, Professor Tu. And do we have more questions from the audience? This gentleman, please.
So thank you so much, speakers, for your informative, inspiring, and hopeful speech. And please accept my deepest apologies for the emergency. And I just trust that no one will arrest anyone at a academic conference, even we are discussing law issues, right? So I just would like to ask a specific question. I believe that the Hague principles of choice of law in international commercial contracts are soft private international law rules, and they empowered parties to choose either state law or soft rules of law to govern their contracts, regardless whether they litigate or they arbitrate. So, however, we understand that in the settlement of international trade disputes, there are two other set of rules of law that parties may choose. The UNDOT Principle of International Commercial Contracts, the PICC, and the United Nations Convention on Contracts for International Sales of Goods, the CISG. So I would like to see the relationships as well as the unique advantages of the Hague choice of law principles over the PICC or the CISG. Thank you so much.
Well, it's a very detailed question. So would you? All right.
Oh, no.
This is actually a very professional question. After the adoption of the Hague principles, actually, somebody has published an article in the American Journal of Comparative Law. That article exactly tells you the answers. I can't ask you to refer to the article, okay? That's too easy to me. Let me answer your question very shortly. The Hague principles say the parties can choose rules of law, well-balanced, neutral rules of law. Suppose the parties have chosen CISG or the Uni-George principles, or you say PICC, right? Things like that. Under the Hague principles, these things should be taken as rules of law that have been chosen by the parties. Clear? I know. Actually, when you are looking at the actual provisions of the CISG and also the Uni-George principles, you would see there are conflicts. There are conflicts between the application of CISG or Uni-George principles here with the provisions in the Hague principles as well. So according to that author, the Hague principles should be revised immediately. Thank you very much.
Thank you very much, Professor Tu. So would Professor Taramura or Professor Panastika would add some points onto this question?
Nothing to add. Yeah.
Okay, thank you.
I do not have much more to add here, but you know, when you asked that question, what I was thinking was because the Indonesian bill also acknowledged the choice of non-state law by the parties, and then the elucidation of this article specifies that rules non-state law is to be understood as the rules that is recognized at regional or international level including those in contract law. So it is open to interpretation, and I think it would also depend on the type of the transaction, because for international contract, of course, we can refer to PICC, or for the specific sales of goods, we can refer to the CISG. But then maybe in other, now I cannot think of anything, the example, but I'm thinking maybe in the other field, there are also other instruments considered as non-state rules that is or that are accepted at regional or international level. So I do not know. I don't think this answers your question, but this is something that I wanted to add. Thank you.
Thank you so much.
Thank you. Thank you for addressing this question. So do we have more questions from the audience? I think we got some time for the one last question. Okay, can we hand the microphone to that lady?
Esteemed panelists, before I ask my question, I just want to share that I submitted an entry to the IBA scholarship program, and the theme was access to justice. And I centered on the availability of options. That said, Professor Tu's presentation mentioned that 88% of arbitral institutions adopt rules that are consistent with the Hague Principles. Yet it is said that arbitration is more preferable than litigation nowadays because of the delays that tend to happen in courts. Though I quite disagree. I disagree with that. In a way, though, I find arbitration a bit restrictive in the sense that the New York Convention mandates the courts to respect the arbitration agreement, even though it is already clear that the party is not going to comply. My question is there a way to harmonize dispute resolution mechanisms, whether public in terms of litigation or private, as to arbitration, mediation, and other modes of dispute resolution, in order to make access to justice more attainable?
Thank you. So who's this question for?
Anyone from the panel?
Hello. Hi.
Hello. Hi.
I hope you can hear me. Harmonizing dispute resolution mechanisms in the world. It's very difficult. But the first point I want to point out is, well, first, I don't think arbitration, sorry, I don't know if I heard you very well, but you said, did you say arbitration is more cost efficient than litigation, or?
No, not really, actually. I said that I quite disagree. Well,
okay, in that sense, I agree with you. These days, arbitration is too expensive, and it's way more expensive than litigation. And actually, I have written a book on this issue, and which was published from Wolters Kluwer, published in 2020. The title of the book is Ex Aequo et Bono, as a response to the over-judicialization of international commercial arbitration. So if you are interested in this particular point, please read that book, or if you have money, please purchase a copy of that book.
Thank you for that.
And harmonizing dispute resolution systems. That is a bit difficult because the reality is there's always some group of people who are making, well, I would say money from a particular type of dispute resolution system. So there are always people who are supporting litigation and who are supporting arbitration, and now there are people who are supporting mediation, like Singapore. Singapore is now promoting mediation very much. So in that sense, those who are supporting different dispute resolution systems are somehow competing with each other, and they are going to harmonize their systems. Maybe unlikely. And yeah, that is my view. And I hope I addressed answered some part of your question. Thank you very much.
Thank you. Thank you, Professor Teramura. And okay, that's it for this Q&A session. Let's put our hands together for our brilliant panelists. Thank you so much for this great discussion. Thank you. All right, ladies and gentlemen, now we are ready to proceed with our final session today, which will focus on the 2006 Securities Convention and the 1985 Trusts Convention. So without further ado, please join me in welcoming our distinguished speakers for this session. Professor Yongping Xiao, Director of International Law Institute of the Wuhan University of People's Republic of China. Welcome to join me on stage. And Professor Dicky Tang, Associate Professor of the Faculty of Law of the Chinese University of Hong Kong, and Professor Adeline Chong, Associate Professor of the School of Law of Singapore Management University, Singapore. Welcome. Welcome, our three guests. Join us on stage. And firstly, Professor Xiao will be delivering an introductory presentation to kick off this session. Professor Xiao, please take the podium.
This one? Good afternoon, these guests, these speakers and guests. I'm honored to be invited to introduce the Security Convention and Trust Convention in this great event. I think the two conventions, let's do the security conventions, where I will divide it three parts. The first, the contract states as to, according to the information from the website HCCH, they said that Mauritius, Switzerland, and the United States is accept the Security Council, which take into force in 2017. And the EU once planned to accept the convention, but the European Central Bank called for cautions. After a legal assessment, the European Commission concluded that convention is a good option to fill the gaps of the European legal framework. But the European Parliament worried about allow the parties to choose the applicable law freely may be detrimental to the stability of the UN financial market. Finally, the European Committee withdrew his proposal to accept the convention. So we need to consider how to attract more states accept this convention. And in my opinion, I think at this historic moment, how to promote this invention around the world is an important issue. Today, I will introduce the core rules of this convention and the comparison between the convention and the Chinese law. If we look at the Article 4 and 5, the choice of law rules in the I sum up the Article 4 and 5 as the tailored legal system. The first is the primary rule is the law agreement in accounting agreement, or as the account agreement provides another law than the other law. But the two limits is that the law should be enforced and the choice should be explicitly. And the supplementary rules have three. It's the law of the relevant intermediate office. It's that, but the writing agreement is entered into through a particular office. The condition is that. And the three is the law of the incorporation or organization and the relevant intermediate. And the condition is the applicable law cannot be determined under the above two steps. And the fourth law is the law of the territorial unit of the intermediate or principal place of the business. The condition is that the relevant intermediate is incorporated on the law of a multi-unit and not that of one of the territorial. If the territorial have more than one place of that, if the intermediate have more than one place of business, and then the principal business of that. And finally, it's forked by clause. It's the law of the intermediate's place of business. In the application condition, we can say the applicable law is not determined under above in the rules or more than one place of business at the time of writing account agreement is entered into. If we can compare the fourth and the fifth, we can, the rule is the same, but we can find the fourth is for particular situation, and the last, the fifth is for by clause for general situation, for general. This is the core application choice of law system we can find. And the convention also gave the limits on the application of the laws in different sets. Only the first is the only 7 issues in relation to disposition or an interest in security held with an intermediaries. This is provided by Article 2, but we should note it's not the right or duty arise from credit security or the contractor or other personal rights and duty of parties to disposition. And the rights and duty of issuer security is not included there. And the second limit is that only if the relevant intermediaries has an office in that state at the time of the agreement. How to determine the office? The convention also gave the rules. It said the office is not engaged in a business or on or other regular activity or maintain security account. There are 4 categories merely because in Article 4.2 it said that not merely, I can say that such as A, not merely because it is a place where the technology supports the bookkeeping in all data proceeding for security account is located. The third limitation is there are 5 circumstances should not be considered. This is Article 5.2, Article 5.1 provided. It said, in determining whether a counter agreement expressly and anonymously states that the relevant intermediate integrate account agreement through a particular office. And the last limit is that the time should be the writing account agreement was entered, or if there is no such agreement at the time of the security account was opened. This is the indeterminate place of the incorporation, organization, business, or principal business. The time factor limitation is the same. So that's the limitation on the choice of law by parties. And finally, I would share with you the Chinese law and the convention and compare that. At present, Chinese B share market is open to foreign investor, and the B share of foreign investor may register their shares in the name of the nominee holder. Qualified foreign institutional investor can apply to open real account or nominee account at security registration and clearing institution. Renminbi qualified foreign institution investors can invest directly in renminbi. Foreign institutional investor can also invest in Chinese security markets through Shanghai, Shenzhen, Hong Kong Stock Connect, Bond Connect, or Shanghai, London Stock Connect. Therefore, the law applicable to intermediate security are also the urgent problem for China to serve. And the regulation, there are two articles should be considered. Article 37 of the law of PRC on the law applicable to foreign-related civil relations of 2010, we can call it Conflicts Acts, provides that the parties may choose the law applicable to rights over movable, where the parties didn't make a choice. The applicable law should be the law of the place where the concerned movable property was located when the relevant legal act occurred. And according to Article 39, provides that security are to be governed by the law of the place where the rights to be exercised, or the law which is most closely connected with the security. These two articles, if we can, and if we combine the two articles, we can find that the Conflict Act may be applied to determine the applicable law to issues regarding intermediate security when the issue in dispute is characterized or qualified as a right of claim, which is the investor's instruction to the direct intermediary, such as request, demanded, voting rights, disposition of security, and Article. Under this circumstance, Article 39 should apply. But meanwhile, Article 37 should apply where the issue is identified as property rights, such as whether the security recorded in the security account opened by the director intermediary are the property of the intermediary, or whether it is a several co-ownership between investors hold the same kind of security in the same intermediaries. That means if it is qualified as a property issue, the Article 77 should apply, and if it is a right of claim, the Article 39 should apply. Just introduce this, we can get the three conclusions, I think. The first is the law choice by the parties are both be applied, but the Hague Convention provides many limits, and the China Act has no statutory limit. Second, the convention emphasizes the connection with the relevant intermediate and provides specific rules for 4 cases. In turn, the place of intermediate office, incorporation, business, and principal business. Differently, China Act focuses on the place where the rights to be exercised, but no legislation interpretation on the meaning of the law where the rights to be exercised at all. Neither guide regarding the place of the closed connection. And the third conclusion, as to the intermediate security, the place of the rights on security are to be exercised to usually right in the place of the intermediate office, incorporation, or business. So we can find there is no major obstacle for China if China accesses the convention from the conflict law's perspective. This is my conclusion. Look, I have another convention. Sorry. As to the trust convention, I will give you some more details for that. According to the website HCCH, as to December 2017, there are 14 contract parties to the trust of the convention, the ratified states, and the accession and the signing person. We can find that among them, Switzerland and Luxembourg are non-trust jurisdiction. Non-trust jurisdiction, it means that these states have no trust law at all at their domestic law, but reflection on the Hague Convention after 13 years by David in 2006 states that the convention has become obliging to another countries. So compare this information. I don't know each information is correct. I hope the HCCH more update that information about the contract convention. If we compare the security concession, the trust convention is being adopted by more countries. We need to think about what's the reason. I think one of the important reasons, I think, is that the trust convention as a conflict laws convention provides some general substantive law from trust thereof, but not by enact by the domestic law of any country. The substantive laws constitute the basic uniform law on trust for the contract city, include those no trust jurisdiction. This is the reason why the title of this convention need to add it on their regulation. Very fair, very rare in Hague Convention system. Some of the provision after Article 2 and 11, there are 3 fundamental laws provisions, which is not provided in any national legislation, but have been supported by most scholars from different countries. The 3 fundamental substantive laws is that the trust assets are a rent fund, It said it gave three subject provision. And the other is the nominal ownership. It means the title to the trust asset stand in the name of trustee or in the name of another person on behalf of the trustee. And the third fundamental rule is the dual structure ownership. The Article 2 define tract as the legal relationship created inter viva or in death by a person, etc., when assets have been placed under the control of the trustee for the benefit of the beneficiary or for a specific purpose. And we should think about what's the meaning of the title to the asset. Title and the asset. Sorry. Actually, if we compare the common law jurisdiction and civil law system, we found the common law theory divided the trust asset ownership into legal title. It is owned by trustee, and the equitable ownership by beneficiaries. And the French theory also classifies it as judicial ownership by trustee and economic ownership by beneficiaries. So the wording of the convention makes it clear that whether a trust is created by a settlor when assets has been placed under control of a trustee or when assets are owned by the trustee, because neither clause require any transfer of asset by a trustee to a trustor to trustee. So a settlor can place the asset under its own control or ownership for the benefit of the beneficiary and not for himself. So in draft this convention, many civil law delegates worried about the concept of settlor make himself a trustor of the property when learning that this called often future property. So the Article 2 provide that the trust that to manage, employ, or dispose of in accordance with the terms of the trust and the special duty imposed upon him by law. This is primarily concerned with express trust property, but may extend to some result and construct trust at an area where the clarifications needed, a clarification needed. And the choice according to the convention, the choice law is also provided the law choice by settlers. That's the articles, but it must express or be implied. Look back, the security required experience, but in contract, the trust contract included implied. And another limit is where the law chosen doesn't provide for trust or the category of trust involves, the choice should not be effective. So the two convention is also different. And the second is the law with which a trust is most closely connected, Article 7, and how to determine the place of close connection. The convention gave 4 factors like that, the second column. And the issues covered by the applicable law according to Article 8 is the law specified in Article 6 and 7 shall govern the validity of trust, its construction, its effects, and the administration of trust. In particular, the law should cover the 10 issues provided in Article 8. Just I can, if we look at the paragraph A, B, and G, we can say that Article 8 is exclusively concerned with the internal trust protector beneficial relationship, but deal with at all, not deal with at all with the liability of third party involved in branch of the trust or external relationship with the third party needing a contractually or directly liability of third party, the trustee or protector. It means this provision have not provide the protector because in practice the citizen often said protector. So in order to deal with citizen regarding protector to protect the interest of beneficial, or sometimes the citizen and have some involved with trustee. Article 8(1) need to cover the appointment, resident, or removal of trustee and protected. And B also added the protector and the G also that. Example, I have also said this. And finally, I gave them the Chinese law and the convention. We can find 2 levels at the substantive law level. China enacted the Trust Act in 2001. Article 2 defined a trust as the act of settling in trust the property rights to the trustee based on its trust in the trustee, and the trustee should manage or dispose in his own land according to the wishes of settler and the benefit of the beneficial for a specific purpose. We can say that there is the convention is the legal relationship. Chinese law is defined that an act. And the meaning, what's the meaning? The proper rights. Is the ownership or other factor of rights. So the provision on the ownership and the ring-fenced of trust or seat and the effects of trust against third party under Chinese law are substantively consistent with those under the Trust Convention. So we need whether the trustee acquired the right to trust property. We can say Article 16, 15, and 7. Because of time limit, I don't explain that. According to the relation between the trust and the third party. So in closing, the provision on the ownership and the range of the trust assert and the effects of trust against the third party under China trust law are substantive concept with those on the Trust Convention. At private international level, the Conflict Act also provide that the parties may agree to choose law application to the trust. If the party have no choice, the law of the status of the trust assets or the law of the place where trust relationship originate should apply. This is Article 7. and where the applicable law cannot be determined according to the foregoing, the applicable law is determined in according to with the principle of close collation. That's Article 2. It is worth note that in past 10 years, Chinese court have never applied the above-mentioned Article 7 to deal with foreign-related trust dispute, mainly because the Chinese court qualify equity trust as non-limit shareholding agreement and thus apply the choice of law for general contract. It provided in Article 41 to choose the application. This statute need reflection, I think. And finally, I gave my compared conventional Chinese law, although the law choice and the closed connection are both adopted. There are some findings, such as Chinese law requires the law choice by parties, and the convention is by settlor, one party. And to apply the law of the status of the trust agent or the law of the place where the trust relation originated before the connection principle. It means Chinese law divided 3 steps, but convention is 2. And the convention provides more details rules on determining the place of the most connection and the issue to be governed by applicable law. So my conclusion is that there is no substantive difference between Chinese law and the trust convention. I suggest China join the convention as soon as possible. Thank you for your attention.
Thank you. Thank you very much, Professor Xiao, for your introduction. Now let's dive into the regional perspectives. So let's start with Professor Tang. Please join the podium. Thank you.
Hi, everyone. My name is Dickie Zhang. Thank you very much for the invitation by the HCCH, particularly invitation from Professor Zhao Yun. I work for a university called Chinese University of Hong Kong, which is a different university from this one. I am, however, a proud alumnus of this university, so it's still great to be here. Professor Zhao has done most of the heavy lifting regarding the convention. I am going to talk about the 2006 Securities Convention. Because my time is limited, so I have done a bit of division labor with Adeline, who will talk about the regional perspective of trust convention. I'll focus on Securities Convention. So without further ado, let's look at what I'm going to talk about very quickly. So 3 things. I'm going to talk about nature of securities held by intermediaries. I will focus on Hong Kong, where I'm from. And next, I will talk about the current choice of law approach of the Hong Kong SAR. Hong Kong has not adopted the Securities Convention yet, so I will talk about the existing law. And finally, I will talk about challenges and opportunities, particularly if the Securities Convention is beneficial to Hong Kong SAR. So very quickly on some background information. So why do we need a Securities Convention or harmonization of choice law rules in general? I think up until 1960s, most of these securities transactions are transacted through paper securities. So there is a certificate for share, there's certificate for bond, etc. So transaction of securities is easy in the sense that you deliver the certificates to the counterparty and transaction is done. So choice of law focused on lex situs. So where is that certificate that will decide the proprietary aspect of the governing law. However, with the increase of international transaction, we have the rise of intermediaries. So they offer a lot of benefits. The securities are held by the intermediaries. The investors themselves do not have the securities. All the transactions are done through book entries. So it saves transaction costs. For example, the issuer only have to deal with the intermediaries, but not the very wide base of investors scattered around the world. This is driven by commercial need. Now, this also creates a huge choice of law problems because the investor no longer deal with the issuer directly. Instead, what they have directly is a relationship with the intermediaries. Now, example of Hong Kong. So Hong Kong securities traded on Hong Kong Stock Exchange, for example, they are held not by the investors. They are held, the stock certificates are held by institution affiliated with the Hong Kong Stock Exchange called the HCCH, standing for the Central Clearing and Settlement System, right? So the issuer deals with HCCH, which held all the securities, the certificates, and HCCH participants, maybe HSBC, maybe Standard Chartered, hold it for the ordinary investors. Now, which law govern the proprietary nature of this transaction, particularly when a bank is involved? So you can borrow money, investor, from the bank and use the securities as collateral. So you no longer have the certificate with you. So lex situs is lacking the original appeal. But what governing law should we use? That's really the issue. Now, different countries have different choice of law approach here. And so we need to decide what to do about it. And harmonization choice of law approach becomes so important, and that's why we have the Hague Securities Convention. Now, Professor Chow has already discussed the Securities Convention in the provisions in detail. I would jump into the second part, which is Hong Kong law. Now, Hong Kong law, as it stands right now, is uncertain, it's unclear. So there's no direct authority decided by Hong Kong court as to what to do with securities held by intermediaries. What we have, though, is an English case, a bit dated, 1996, English Court of Appeal decided in the Macmillan case that the English court would apply lex situs. Now, this case is heavily discussed and debated. You know, the CA actually did not consider the facts that the securities in question were held by intermediaries. They knew about it, but they did not focus on this feature of the case. Daisy Morris challenged the lex situs rule, thinking that this doesn't make sense. Instead, we should really look at the place where the depository is established and where it keeps the database in which the entitlements of depositors are recorded. So Hong Kong approach, in summary, you can argue that we should follow Macmillan, which is the looking through approach. You only apply the law of the place of incorporation, right? And it has some supported from some commentators. For example, Johnson and Harris, authors of the Conflict of Laws in Hong Kong, supported this idea. The argument is, well, that meets expectations of all parties. Now, I talked to a corporate lawyer friend of mine here in the city, and he wasn't aware of the Hague Securities Convention. And when he thought about this choice of law question, the first thing he came up with, well, law of the place of incorporation. The problem of law of the place of incorporation, however, is that, yeah, you no longer deal with the issue directly. Now, the alternative approach here is the one suggested by Daisy Morris that we talked about before. We look at the place the law of the place of intermediaries. And the general principle here, the rationale, is that the situs of the shows of action should be where it is recoverable or may be enforced. It has, this argument has support from many commentators around the common law jurisdictions, and it's also similar to the EU directives right now. So in summary, the current law is unsatisfactory because it's uncertain. We don't know which approach to take, and it's not in line with international practices. So finally, we have to consider whether it is a good idea for Hong Kong to adopt the Hague Securities Convention. I mean, technically speaking, Hong Kong SAR cannot sign the convention because it's open up for signing only by state. However, China can sign it, and China can also choose only to apply the territorial unit of Hong Kong as well. So Hong Kong alone is okay, along with China is okay, all right? Currently, there are only 3 jurisdictions that have signed the Hague Securities Convention, not including Hong Kong, of course. And you can argue that the existing rule, at least one of the prevailing approach in Hong Kong, PRIMA, stand for the law of the place or the relevant intermediaries approach. Effectively, we're looking at the law of the place account, reflects commercial realities. If you pay attention to Professor Shao's introduction of the convention's rule, Article 4 is an advanced form of PRIMA, you can argue, because it respects party autonomy, and the PRIMA is actually a fallback rule, at least one of them. The other advantages, well, it makes sense to reflect the commercial realities, and also it is also compatible with China, which Professor Shao has already introduced. So to sum up, there are also some challenges because for now, 2 of the 3 jurisdictions, at least I know, Switzerland and US, they signed the convention because the rule of convention is more similar to what they have already in place nationally. So it's easier to follow to sign the convention. On the other hand, other jurisdictions have reservation. For example, EU has reservation because, for example, that if you respect party autonomy, it also means that the same intermediary could apply multiple laws. And there's also concern that if parties are allowed to choose the law, it will kind of allow them to escape these mandatory laws imposed by the relevant jurisdictions. Then also there are technicality issues. I mean, the convention is not the easiest to navigate, particularly for non-lawyers. So in conclusion, I think the choice of law on intermediate securities in Hong Kong currently is very important to Hong Kong as a financial hub. However, the uncertainties are unsatisfactory of the current law. Hague Securities Convention offers solution, harmonization with other jurisdictions, that's great. However, whether it's to adopt, of course, it depends on China. And also what other jurisdictions are going to do. I mean, if EU softens its position, it would become a more prevailing trend around the world to adopt the convention. So that's my presentation. Thank you very much.
Thank you. Thank you very much, Professor Tao, for your perspectives. And lastly, let's continue exploring regional perspectives with Professor Adeline Chung. Please take the podium.
Okay, good evening, everyone. I would like to first thank the HCCH for their very kind invitation to me to speak at this conference. It's a real privilege for me to do so. And I would also like to thank the organizers, especially Professor Yun Zhao, for the very efficient organization and warm hospitality. Now, as Dickie mentioned, I'm going to focus on the 1985 Trust Convention. On the first day of this conference, Dr. Bernasconi, when he was speaking of the role of the HCCH, used this analogy of building bridges, right? And this analogy is particularly apt when we're dealing with the Trust Convention, because it deals with an institution which is more naturally associated with common law jurisdictions compared to civil law jurisdictions. But of course, the trust is not totally unknown in civil law jurisdictions, so the bridge to be built is actually not between common law and civil law jurisdictions, as is the popular misconception, but rather between trust jurisdictions and non-trust jurisdictions. Okay. Now, the Trust Convention has had a relatively modest number of ratifications and accessions overall. So in the Asia Pacific region, it's only enforced in Hong Kong SAR and Australia. And in my presentation, I would like to explore why the convention is not that popular, relatively speaking. Okay, but before that, I would just like to make a brief point regarding the scope of the convention. Now, Professor Xiao, in his earlier presentation, helpfully took us through the Article 2 description of a trust, so I won't go through that again, except that I would just like to note that the Article 2 description of a trust is rather wide in nature. Right, as previously mentioned, under the classic common law trust, there's that split in ownership. So the trustee has legal title, the beneficiary has equitable title. And that split, that's not mentioned in Article 2. So the scope of Article 2 is pretty wide, and it covers not just the classic common law trust, it will cover analogous institutions. So for example, the Islamic Waqaf, which is adopted in jurisdictions such as Indonesia and Malaysia. And you'll see that I've set out the sort of core principles underlying the Islamic Waqaf. And the parties involved in the Waqaf play roles that are analogous to that of a settlor, trustee, and beneficiary. So the Islamic Waqaf actually would fall within the Article 2 description of a trust. Yeah. So one point to bear in mind is that the convention has the potential to cover legal structures other than the classic common law trust, which is of course not universally adopted in the Asia Pacific. I'm afraid I don't know enough about decentralized autonomous organizations to be able to answer Professor Go Escola's earlier question as to whether or not a DAO would qualify as a trust under Article 2. So I need to do further research into that point. Okay. So now I consider potential reasons why the convention has not gained much traction in this region. And for this, it is important to bear in mind that the convention has two main aims. So number one, it seeks to harmonize the choice of law rule for trusts. And number two, it spells out the minimum effects of recognizing a trust, which is valid under its applicable law. Okay, so let me deal with jurisdictions which do have the trust and jurisdictions which do not have the trust in turn. So for the first category, now of course this includes the common law jurisdictions such as Hong Kong SAR, Australia, Malaysia, Singapore, who all adopt the English classical model of a trust. But a large number of civil law jurisdictions also come within this list. So Japan introduced the trust into its law by way of the Trust Act in 1922, and this act in turn influenced various other trust statutes in other jurisdictions as listed in this slide. Okay. Now, the common law jurisdictions where trusts are well established may not actually have much of an incentive to sign up to the convention, right? If you think about the two objectives, in relation to the objective of harmonizing the choice of law rule for trusts, the convention's choice of law rules, they largely follow the common law choice of law rules anyway, right? So in that sense, the convention doesn't really add much to the existing laws for these common law countries. And further to that, it is generally accepted that beneficiaries have an equitable proprietary right in the trust asset under the common law trust. The convention's choice of law rules, they don't quite deal with this particular aspect. And in fact, if we look at Article 11.3d, the last sentence, which I've reproduced here, well, this may raise an issue. The choice of law rules for property matters is usually the lex situs. So if the lex situs is the law of a civil law jurisdiction, right, the court of this civil law jurisdiction the law of this civil law jurisdiction would be unlikely to accept the common law principle that a beneficiary's right in a trust property will persist against everyone except for a bona fide purchaser for value without notice. Now, the second objective of the convention is setting out the minimum effects of recognizing a trust, and this is intended to familiarize jurisdictions which do not have the trust with the institution. So this second objective also doesn't confer any particular benefit to jurisdictions which are familiar with the trust. The convention has universal effect, and this means that the applicable law under the convention need not be the law of a contracting state. Right? This is subject to a caveat, right? Unless a contracting state has lodged a reservation to only recognize trusts which are governed by the law of another contracting state that's pursuant to Article 21. But it should be noted that to date, no such reservation has been lodged. Right. Nevertheless, Australia and Hong Kong SAR, both common law jurisdictions, have signed up. I think this can be justified because I think the common law jurisdictions cannot quite expect civil law jurisdictions to ratify the convention if they themselves are not willing to do so. Now I move on to civil law jurisdictions. So in contrast with the common law jurisdictions, the trust is a relatively new institution in other jurisdictions. Now, the trust was only introduced into Chinese law in 2001, but it does have choice of law rules for trust, but Professor Xiao has covered this, so let me skip this part. I have to say, though, that China is a bit anomalous in having choice of law rule for trust within the civil law jurisdictions. Even jurisdictions which have adopted the trust for some time, like Japan, South Korea, to my understanding anyway, they have not quite developed or they do not have well-established choice of law rules for trust. So signing up to the convention may be attractive for this reason. And some other jurisdictions like Cambodia only introduced the trust into its law in 2019. So it doesn't have any trust choice of law rules or underdeveloped trust choice of law rules. So signing up to the convention will also similarly be attractive in that regard. However, it is also possible for these jurisdictions without established trust choice of law rules to simply follow the rules in the convention without formally enacting the convention into their laws. And indeed, this has been the case in some jurisdictions, such as Belgium, Quebec, Romania, and the Czech Republic. Now, I need to deal with a subcategory, offshore trust jurisdictions, because a few jurisdictions in the Asia Pacific do have a healthy offshore trust industry, right? Now, for offshore trust jurisdictions, their considerations on whether to sign up to the convention is going to be different, right? Offshore trusts, they generally have characteristics which veer from the classic common law trust. So the settlor retains greater autonomy over the trust. The perpetuity periods can be very long or it could be non-existent, right? The statutory trust choice of law rules in these jurisdictions, within the Asia Pacific anyway, they mirror those found in the convention. So there's no deviation no great deviation anyway from Article 6 and Article 7 of the convention. But some of the other provisions of the convention may not be very attractive to offshore trust jurisdictions. For example, if you look at Article 15.1c and Article 16, now the effect of these provisions actually would allow for the application of forced heirship rules, even if the governing law of the trust does not have forced heirship provisions. So these more restrictive effects of the convention, which impinge on settlor autonomy, may not be so attractive to offshore trust jurisdictions and may also be of concern to jurisdictions which are looking to attract the establishment of family offices for high net worth individuals, such as Singapore. Okay. Now I move on to jurisdictions which do not have the trust in their law. And I think Vietnam is one of the examples of Asia-Pacific jurisdictions in this category. Although given the wide description of the trust in Article 2, I think the number of jurisdictions in this category is likely to be, well, not going to be too large. Okay? So one important part of the convention is to familiarize jurisdictions in this category with the trust and to provide a framework for how their courts are to deal with this unfamiliar institution. Now, civil law European jurisdictions without the trust and which have not enacted the convention, they usually try to deal with the trust consistently with a local functional analog. And Professor Xiao earlier mentioned that under Chinese law, the practice is to deal with the classic common law trust by way of contract. And indeed, in the Swiss courts, prior to enacting the convention, actually did characterize the trust as contractual in nature. Okay? So the option of dealing with trust consistently with a local functional analog is, of course, an option available to similarly placed Asia-Pacific jurisdictions. But as a general principle, enacting the convention would be a better solution because it would provide clarity, it provides certainty at both the transactional and litigation stages. Okay? It has, however, been noted that jurisdictions within the Asia-Pacific, without the trust, they are rarely faced with cross-border trust disputes. So I think it is understandable that the motivation to ratify the convention is not terribly strong. Okay. And in conclusion, right, the convention is a product of compromise. On the one hand, it had to provide workable rules on choice of law and effects of recognizing the trust. And on the other hand, it had to cater to the concerns of civil law jurisdictions, which at the time the convention was negotiated, they had many fears about the trust. Okay? So because of this, the convention has perhaps ended up not particularly attractive to trust or non-trust jurisdictions alike, but for slightly different reasons. Now, jurisdictions which already do have the trust need to understand what value will be added if they sign up to the convention. And I would say that signing up may encourage non-trust jurisdictions to follow suit, and that will in turn lead to more trusts being validated across board. Signing up may also perform a signaling function. What Professor David Hayton, who at that time, he was the head of the UK delegation negotiating the trust convention, termed as evidence of being a good, respectable trust jurisdiction. Right? Asia-Pacific jurisdictions which do not have the trust generally do not face many cross-border trust disputes at this point in time, and they would have to be willing to engage in some forward planning to be incentivized to ratify the convention. Thank you very much.
Thank you, Professor Chung. Thank you very much. And a big thank you to all of our great panelists and all the speakers today for excellent presentations and contribution to this conference. And that's it for our day 3 of the conference. Thank you for engagement. Thank you very much for joining us. And I believe you've all had a very productive and fruitful day, and I wish you a very good night. Thank you very much. Ladies and gentlemen, I'll see all of you again tomorrow. Thank you. All right, so the guests who got invited to the Llama Island for the dinner tonight, please follow 2 of our students' ambassadors at the back of the room. And we have a coach arranged for you departing at 6:30 p.m. in 10 minutes. So please follow our 2 students' ambassadors to go to the gathering point. Thank you very much. And for those attending tomorrow's conference, please don't forget to bring your lanyards with you. And also, for those applying for Law Society CPD points, please remember to sign the list at the reception. Thank you very much. Have a good night.